I am led by Advocate General in this matter, my lord. As per his instruction, Lordship, matter may be fixed on next Tuesday, my lord. I have taken the consent of the other side also.
This is with regard to that eviction matter.
Eviction in Biotech Park, my lord.
This court had literally settled the matter last time. Now they have an application for,
Has been rejected, my lord.
has been
That is
rejected.
why that second writ petition has been filed, my lord.
there is a second
So,
petition.
merit hearing is required. my
The second latest
Yes,
one.
yes.
After the notices are issued, what is the process involved under 18.3? There has to be some process, some hearing, something.
Yes, my lord. In this matter, they are pending representation.
Because your right to issue that notice was not questioned by this court. Only the thing where it was questioned, what you had not issued a notice.
Yes, my lord.
Now
Yeah,
that-
notice has been issued, my
Issued.
lord.
Okay. Tuesday.
Tuesday. That interim order
There's an
has to be
interim in
continued.
Huh?
the matters. There's an interim that may kindly continue.
On the prayer made on behalf of the learned Advocate General, Assam, and not objected to by the learned counsel for the petitioners. The writ about the said about the writ petitions are, the hearing of the writ petition is adjourned today, full stop. As agreed to by the parties, registry to list these matters again on Tuesday, 13.
Deeply.
13/8/2024. Interim orders passed earlier to continue till the next date of listing.
Deeply.
May I please?
Yes, Mr. Chair.
I beg to mention item number 8. Lordship, due to the yesterday's situation, I couldn't prepare.
Okay, that is a genuine thing.
Lordship, either any date, Lordship.
Mr. Chetia,
No.
one thing, just my information, it's new factor for me. Now in that schedule,
What?
wireless equipment is prescribed.
My lord.
You have not brought on record anything to show that this is not coming within that category. Set-top box and something is exempted, but these two materials, the materials, they also, as a common man, is in connection with wireless activity.
Otherwise, it is included, my lord.
Then
My lord.
where is that material to show that this cannot be brought in?
My lord,
Because this has its own independent uses.
my lord.
Hmm.
In fact, my lord, we are relying on the Supreme Court judgment. That
Hmm.
Supreme Court judgment,
What is that?
which says, my lord, I'm sorry, my lord, record is right now on.
You can just give a citation to him.
My
So I
lord,
can just
furnish
prepare
a
myself.
Copy, my lord.
Furnish a copy. When do you want it?
Any date, Lordship.
We'll have it on 14th.
My lord, 14th, I have some difficulty.
16th.
27th, my lord. Or Thursday, coming Thursday, day after tomorrow.
8th. 8th.
Lord.
8th.
My lord. I'll
As
consider
prayed for
judgment
by
today.
the learned counsel for the parties. Registry to list this matter again on 8/8/2024.
Deeply obliged.
Item number 8.
Obliged.
Just give a
My
copy
lord,
of
I'll furnish today itself.
Okay, Your Lordship, I'd like to mention item number 24 on behalf of Mrs. N. Bora. She was informed by the petitioner today morning that due to waterlogging, they are unable to come.
Item number 24.
24.
On the prayer of the learned counsel for the parties, registry to list this matter again on 27/8/2024. Today, waterlogging, we can say nothing. Mr. Sharma, your judgments I was dictating, but you had relied on 2 decisions. Do you have the copies of that? Can you just give me those copies?
After some time,
I just give it. Egita duta bazar mati dile ho. Delivery of orders duta bazar through.
Back to you.
We'll pass the orders, don't worry.
Yeah.
I don't know how because yesterday's backlog is still there. So if possible, we will do it today.
after some
Or
time,
I'll dictate the orders and I'll deliver it by Thursday or Monday. It will be listed again, don't worry. It will be listed. It will not be disposed of, don't worry. It will be disposed of in court only.
after some time.
You just give it. 2 decisions were.
Yes, yes, good.
I have I forgot to note the citations. Only the names I have. Approximately. Serially material.
Top of the list, item 7.
Should we kindly take up this matter after some time?
My lord, Mr. D. Nath is appearing in this case, my lord. So, as per, he has requested me to pray for adjournment
Why?
today.
13 matter.
My lord,
Last time also.
because of lordship. Can ask him, but he has requested just now.
No,
that-
why? What? Give me a ground. Give me a ground. Without a ground, how can I?
God bless.
And only thing, you have taken a plea that disputed questions of fact.
Lordship.
But if we remove, there is only one area of dispute. Whether they have telecasted 6 commercials or 12 commercials.
Number
Now
is
you show me how they were required to telecast 12.
Lordship, yes.
Because the director, producer of that commercials
Commercials.
has written a letter wherein he, after the 6 had been telecasted, saying that I have it ready with me, I can give it. So how can they be held to be responsible? And you had processed the matter for payment of around 63 lakhs.
My lord. I had an occasion, I appeared in the now, I remember, yes, after that he has.
So
been
just
taken-
ask Mr. Nat if there is any serious problem, we will accommodate. But this is the only area where we'll have to look into, right, madam? Ask Mr. Bhuya to be here.
Lordship.
We'll have it after the admission matters.
Lordship.
Where is Mr. Borpujari?
Number 17 online.
He'll be arguing or you will be arguing? Who will be arguing this matter? You will.
We have filed our affidavit, madam. There we have clearly stated, madam.
Mr. Satar,
My lord,
new topic for me. Just one clarification. Earlier, this was an agricultural land.
yes, my lord.
Has the nature of the land or the area of placement of the land from a village to a town occasioned? If that has occasioned, can the act be still applicable?
Yes, my lord. My lord, I knew that your lordship will be.
Oh, no, this is just a query. I don't know. That's why I'm asking
My
you.
lord, in the year 1983,
Huh.
when the the urban agglomeration was extended,
Hmm.
at that time, that area was brought into the urban area.
Hmm.
And even if it is brought into the urban area, my lord, the tenancy which was there since the year 1962 would continue. And I do have the right, and for that purpose, my lord, I have a judgment, Vikram Fugan versus State of Assam and others.
Just show me.
Yeah.
Because this was something which, I know it may be a wrong question, but this is some doubt.
It's a very pertinent question, my lord. Cannot be said to be wrong.
Can I have that judgment?
Yes, my lord, I have already given.
Where is that issue dealt with? Okay.
My
Para
lord, if I
17.
can take your lordship to page number 8
Para 17.
from the report of the sub-deputy collector of the second para, my lord.
Aha.
On examination of entire record, I am of the opinion that the above named buyer is entitled to get ownership right by giving compensation to the landlords equivalent to 50 times of the land revenue, which is presently rupees so and so per year, as per Appendix 24 of the Assam Tenancy Act so and so. But before that, if I can take your lordship to the top of that, it is to be worth noted. It is to
Land
be-
covered under this so and so, but from so and so
Not the land covered under this falls within the Guwahati Municipal Corporation.
will be
area.
entitled to
But from
enjoy.
the letter number so and so dated so and so received from the government, it appears that the people who had got Rayati rights covered within the Guwahati Municipal Corporation area will be entitled to enjoy Rayati rights so long any other enactment does not curb their rights. The new amendment provision of so and so 1983 Amendment Act in the year is not applicable.
1688 cannot assign that. And whatever has already reserved for construction of termination.
Now, what about what is the purport of this para 17?
Yes, my lord. After the Guwahati municipal.
Because we have an act and a government had given a executive instruction for clarification of the rights, subject to certain amendments if made in future.
My lord.
Were any amendments made to that temporarily act in future, excluding these people?
As of date, not within my knowledge, but this judgment is confirmed by the division bench also, my lord.
Okay,
Eh,
along with para 17.
Para 17.
Okay. My Lord Justice N. Chaudhary was there.
Yes, my lord.
Yes, Mr. You can start.
Para-
I got it. You can start. Mr. Hazarika, I had a doubt whether the placement of that situs of that land from a village to a town or like a city like Guwahati, whether the provisions of the act would be applicable, still continue to apply. So Mr. Sattar has placed two decisions. One, a single bench, which was affirmed by the division bench, which says that no, the rights, righty rights that were acquired shall continue to.
Yes, righty rights unless, my lord, that has been, my lord, cancelled by the operation of law.
Law, but he says there is no law brought into effect, having brought into operation, having the effect of cancelling those rights. There is no law, I suppose, as well.
So, my lord, it is.
Now this government college for which the land was being acquired has it come into existence? The land that was acquired,
Yes.
including your land,
Yes.
it was for a government
For
college.
that, my lord, no notice was issued to us.
There was no notice.
No, no.
And there is some, okay.
Moreover, if I can take your lordship to page number 31,
Hmm.
the area which is shown to be
Hmm.
from where I am to be evicted, my lord, is only 2.68 R. That is equivalent to only 1 kattha, my lord.
Hmm. Hmm.
Page number 21, my lord. But I have been evicted from 3 bigha 2 kattha of land. Out of 5 bighas, 4 kattha 7 lechas, which was belonging to my landlord, under whom I was the occupancy tenant. My lord, 21 is the page number 31, my lord, is the translated copy of that.
What is the present status with regard to that land? Are you still in possession?
No, no, my lord. I have been forcefully evicted. That's why I have filed, my lord.
Why the two affidavits were required to be filed? Because some contradiction in the affidavits
Yes, my lord.
by Pallab Kumar Jha, DC.
Right.
One, he says something, subsequently he says something.
Yes, my lord, yes.
And he even goes to question as to whether the Patadar had given you the permission, some to that extent.
That is not within his jurisdiction.
No, that be that as it may, but those are the two affidavits filed
Yes, my.
in pursuance
And
to
both
orders
are
of,
contradictory to
both
each
are
other.
contradictory.
Now, the
Okay,
deposit.
tell me the facts. Tell me the facts.
My lord, my father
Hmm.
was, rather the land was allotted by the government of Assam to one Khasnur Ali
Hmm.
and my lord Sukhna.
So he was the Patadar.
He was the Pattada.
Hmm. He is
And-
no longer, his heirs are in place.
Yes, my lord.
Hmm.
And if I can take your lordship to that, Patta number, it is Patta number draft Chita, Patta number 19, page number 20, my lord.
Hmm. Hmm.
So, my lord, there your lordship will be pleased to see that the land over which my landlord was having the right title interest was 5 bigha, 2 kattha and 7 lecha. Annexure A, page number 19.
5 bigha.
5 bigha, 2 kattha, 7 lecha, my lord.
Huh.
And your lordship will be pleased to find the name of the Pattadars as Khasnur Ali,
Hmm.
father's name Thanu, and Sukhna Sheikh, father's name Amir Ali. My lord, I would like to read before your lordship the down below, I mean the sentences. As per order dated 21/10/1960, passed by the SDC in case number 337/28/10/1960 on petition number 1304 of 1959-60, land measuring 5 bigha, 2 kattha, 7 lecha has been converted into Miadi Patta land on receipt of a premium of rupees 27.
Okay, your father's name is also
Yes,
included
my
there.
lord, thereafter, as per order dated 25/8/1962, passed by the ASO in petition number 102, name of Shri Biren Borgohain has been entered in Chitta as Raiti on the basis of his position. So my position was there in respect of my lord, this area of land, and I was accordingly issued the
Khatian.
Khatian number 31. my lord.
330.
And this Khatian, my lord, is certified copy of the Khatian of village Pachim Buragaon under Moja Jalukbadi for the year 1975-86. Rayati's name, father's name, Viren Borgohain. Then, my lord, thereafter your lordship will be pleased to see Bulbuli, after the demise of my father, Bulbuli Borgohain, who is the petitioner. before
What
your
is the land here? Is it 2 kattha? Land is
3 bigha 2 kattha, my lord.
top portion. 5 bigha.
5 bigha 2 kattha 7 lecha, my lord, was the
Original.
total land. It is in vertical way.
Uh,
That was the land belonging to my landlord.
How much is in your possession?
3 bigha 2 kattha for which I was issued the Khatian, my lord.
3 bigha 2 kattha.
Yes,
Okay,
my lord.
then.
So I was possessing the same.
Hmm.
My landlord was also satisfied.
Hmm.
All of a sudden, my lord, this notice was issued
Hmm.
at page number 31.
So no, you had applied for
I
the
had applied, my lord.
at page 25.
I had
When was
applied-
this done?
That was for the acquisition of ownership right, my lord.
Hmm. When was this application made?
This application was made, my lord. It is in the month of October 2013, my lord. Exact date is not there, my lord,
Okay.
but it is in the month of October 2013.
Then what happened?
Thereafter, my lord, immediately this notice was issued without any date. That is page number 31, my lord. And my
And
lord,
here it is only 1 kattha.
1 kattha, my lord.
And does the other land DAG number and all match?
Tag number 704/1105,
This is the new one,
1688 is the new one, my lord.
1688.
Just down.
But
16.
in the Khatian, the DAG number is 771.
Yes,
So where does this DAG number 704 come from?
771 comes from 704, my lord.
It's conversion.
Yes,
Then it became 1688.
1688.
That,
1688.
so this
yes.
is the new one.
Yes, my lord.
Just prior to that, it is 704.
My lord.
And prior to that, in 75, 76, it was 771.
Yes, my lord.
Sure. It's the
Yes,
same
five-
land.
574 old, 771 again old,
Hmm.
then 730 new. That is by way of conversion. And it is all pertaining to, my lord, Patta number 135.
Okay.
It is not the Sarkari land when there is a Patta, my lord. Not the government.
But they had denoted it as
They have denoted is without any Patta.
Sarkari Unusthan.
No Patta is mentioned, my lord.
If you come to the vernacular one, Moza, so and so, so and so, so and so, Matir,
Moja Jalapuri,
Kali,
village Pachim Bordo.
Matir Bibaron, Hadaron Sarkari, Sarkari Unusthan. So this is land reserved for some institution.
According to them.
Then what happened? You submitted an application.
Then, my lord, I was ultimately evicted from there.
Hmm.
When there was a threat to evict, then I filed the writ petition.
Hmm.
A status quo was granted, my lord. A status quo was granted by order dated 35/2014. When our position was about to be disturbed, then I filed the writ petition, my lord.
Then
And-
what happened? But in spite of that status, was made.
Yes.
Any reply to this?
Now, if I can take, with this regard, if I can take, your lordship has already perused those two affidavits.
Hmm.
Affidavits.
No, but take me through that. In your perspective. The RTI reply, they did not furnish to you.
No.
Then,
Okay, yeah. Then all the other as the documents, my lord, regarding showing of.
so this eviction occasioned in which year? 2000?
My lord,
Eviction occasioned in which year? 2014.
2014.
And you were paying the land revenue till when?
Yes, my lord.
You were paying,
The
Till
land revenue
2014?
then. Yes, my lord. That is the proof I have already.
your 7 is there. 9 is there.
Starting from.
11
December
is there.
52,
12
my lord,
is
yes.
there.
2006, 2007,
13.
2007, 2008,
No.
2008, 2009. And the small house which I had was also asset by the GMC, my lord, that I have also annexed at page number 55.
Okay, proceed. You were paying the electricity bills also. Now we can go straight to the affidavit. So your prayer in the present proceedings is that eviction has become
Illegal, my lord.
illegal,
Yes.
according to you,
My prayers are, my lord, at page number 14.
or you are to be compensated for the land that was acquired from your. Now, the land that was acquired from they say they had acquired that land from your landowner.
My lord, then there should be some acquisition notice. under
No.
section 4 and 5.
Was any compensation paid to the landowners?
No, my lord.
Sure.
Yes, ma'am.
Okay, now come to the first affidavit of the.
My lord, the first affidavit is appearing at page number 65. And if I can take your lordship to paragraph number 4 and 5, my lord. I will read the entire affidavit, my lord.
No need. You can just stick to what you want to show me.
Yeah. So paragraph number 2, I have narrated, my lord, that the honorable court by order dated 14/9/2023 has directed me to clarify my stand with regard to the communication dated 6/1/2022 addressed to the commissioner and secretary to the government of Assam. I will take your lordship to that letter also.
That letter he had sent. Then
By the
he
deputy-
subsequently says that that was on an error I had sent it. It was erroneously sent.
Right.
So clarify those aspects here.
My lord, the letter dated is at NHC page number 9 of the second affidavit.
Hmm.
May I read that one?
Yeah, you can.
It is addressed to the Commissioner and Secretary to the Government of Assam Revenue and DM Department, Dispur, Guwahati. Ownership right in favor of Srimati Bulbuli Borgohain, daughter of Biren Borgohain, who was a recorded tenant. With reference to the subject cited above, I have the honor to inform you that the petitioner Srimati Bulbuli Borgohain, daughter of Biren Borgohain, has applied to get ownership right of land measuring 3 bigha 2 katta 0 laksha covered by DAG number 704 old 1688 new of KP Patta number 135 bearing Khatian number 301 of village Pachim Buragaon under Jhalukbadi Moja as per provision of Rule 16 of the Assam Temporary Settled Areas Tenancy Act 1971. While examining the draft chitta of village Pachim Buragaon in the year 1923-28, it has been observed that name of Biren Buragaon was recorded as tenant over DAG number 770/771/574 for an area of land measuring 3 bigha 2 katta. Again, as per land records of 1975-86, name of the petitioner of the instant case Srimati Bulbuli Borgohain was recorded as tenant in place of deceased tenant Biren Borgohain. It has also been recorded that new DAG number 704 and 705 were the part of old DAG number 770 and 771, my lord. The petitioner was evicted from the DAG number 704 old /1688 new in the year 2014 as because the land record prepared after the resettlement operation where DAG number 704 old /1688 new is recorded as government land, not as KP Patta land where tenancy was created. Therefore, after evicting the petitioner, one proposal was submitted by the Circle Officer Guwahati Revenue Circle for allotment of said land for establishment of family court, which is still pending. But as the matter is under the disposal of the Honorable Guwahati High Court and WPC number 2639/2014, which is yet to be disposed of finally, and earlier order court has mentioned that the petitioner is the legally recognized tenant of the above mentioned scheduled land. Further, the land where the petitioner was evicted in the year 2014 from DAG number 704 old 1688 new of village Pachim Buragaon was originated from the old DAG number 770/771 of village Pachim Buragaon, where the name of the petitioner was recorded as tenant. Again, as per the provision of the Assam Temporary Settled Areas Tenancy Act 1971, the recorded tenants are eligible to get ownership right over the land under his/her tenancy, subject to deposition of 50 times land revenue as per current rate as premium. After the resettlement operation, the DAG number 704, 1688 new, which was under her occupation on the petitioner. Therefore, you are requested to kindly accord necessary approval for correction of DAG number 704 old /1688 new from the government land to KP Patta land and initiation of tenancy case from this end.
So by this letter per se, a projection can be made that the conversion of your land as a government land was wrong. Was erroneous, so they have prayed that it should be taken back.
Yes,
Now come to the affidavits.
Now I am taking your lordship to the first affidavit, which was
Paragraph 6 is in tune with that letter.
Yes, my lord. Paragraph number 5 and 6 is
In tune.
with
You can come straight to paragraph 7. Here,
in paragraph.
he makes a change.
Yes.
Ah.
That your deponent respectfully begs to state that land measuring 802.68 R under Dag number 704 old 1688 new. There is a correction, my lord. In the typing, it was 1088, but there is a correction, my lord, which is government land, and the same has already been reserved for construction of family court. But inadvertently, it goes out of my knowledge, and because of that, under a wrong notion, a
A request
request
was
was made to the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department, Dispur Guwahati 6, for correction of Dag number 704 old, 1688 new from the government land to the KP Patta land. My lord, if this version is considered to be true for the sake of argument, my lord, then where my land is, which I am occupying since the year 1972, my lord, yes. And that too, where a patta was granted by the government of Assam to Kasnur Ali and Sukna.
So this will also subsume the land of your landlord. Okay, then the second affidavit.
Then the second affidavit.
In terms of orders of this court.
Number 2.
Hmm.
That the Honorable Court, while order dated 19/9/2023, has directed me to file an affidavit to clarify whether the land covered by Dag number 771 old, 730 new of KP Patta number 135 of village Pachim Budagaon under Jalubadi Moja, as included in the land covered by Dag number 704/1688 new of village Pachim Budagaon under Jalubadi Moja. The Honorable Court further observed that on the basis of an order dated 21/10/1960.
This is from the chitta you read at page 19.
My lord.
This position is evident from page 19 of your writ petition.
Yes. The Honorable Court further observed that on the basis of an order dated 21/10/1960, a plot of land measuring 5 bighas 2 katta 7 lecha from Dag number 771 was settled in favor of Kasnur Ali and Sukna Ali. In that case, the same could not have been a part of government land. The Honorable Court further directed to file the affidavit in terms of the earlier order dated 14/9/2023, as well as the order dated 19/9/2023, clarifying our stand. That your deponent begs to state that I have verified the land documents, including chitta copies, as well as the trace map of the land. in
Mr.
question.
Sata, you need not take the trouble of reading further. You can come straight to page 79, internal page 3 of that affidavit.
Page 3, yes, my lord.
Because he says that this is the land of your owner, landlord. Now he is replaced by his heirs. Now you read, and others are recorded pattadas during field verification. Page 3 of
Page
that affidavit.
Of that
1,
affidavit.
2, 3.
Just a minute.
Running page 79, internal page 3, starts with 5 bigha, 2 katta, 7 lesser.
79.
No. This same affidavit,
69, my lord.
maybe some mistake may be there. Internal page 3. 5
Internal-
bigha, 2 katta, 7 lesser, presently Mohammed Muzamuddin Ahmed.
Yes, my lord.
Just come down.
Yes, my lord, I'm coming to that, my lord. After completion of the settlement operation, the Dag number 1763 new and Miadi Patta number 605 new have been created from Dag number 730 old and Miadi Patta number 135 of Revenue Village, Pachim Budagaon under Jalubadi Moda. As per record, the said Dag covers 73.29 R, which is 5 bigha 2 katta 7 lecha. Presently, Muhammad Mujamuddin Ahmad, son of Sukna, and Muhammad Sabed Ali and Gul Muhammad, both are sons of Kasnur Ali. Saira Khatun, wife of Mujamuddin, and others are the recorded pattadars of said patta. During field verification, it is found that the writ petitioner had occupied the land covered by Dag number 704/1688 new, which is government land instead of Rayati Thatian land of Dag number 730/1763 new. The land covered by Dag number 704/1688 new, measuring of 802.68 R, is the government land, and the said plot of land is already reserved for construction of family court, and the petitioner was evicted from the said government land way back in the year 2014.
Now, what is the purport of this paragraph?
My lord, I would like to submit before your lordship that so far the issuance of Khatiyan is concerned, it is made by the government only on the basis of the field verification. And when a Khatiyan was issued in the year 1962, my lord,
Hmm.
it cannot be said that it was issued without there being any verification from the Lat Mandal and the circle officer. And since the year 1962, my lord, when I was found in possession of that plot of land for which a Khatiyan was issued, how that can overnight change and take
Because
place in
Mr. Sattar,
Yes, madam.
here that 5 bigha 2 katha 7 lessa, which is the land, whole land,
Yes, my lord.
under which you are a righty,
Yes, madam.
that has been shown separately.
Yes.
And therein you are not figuring.
There I am not figuring. Yes.
You are figuring in a government land.
Yes.
Now, the very citus, this court, how will this court go by way of affidavits and conclude that no, you continue to be occupying a land under 5 bigha 2 katha 7 lessa and not under the government?
That's
Which
what
might, this may be contiguous lands because this dag contain more than 5 bigha.
True,
So that whole dag, a part is a landlord. You were under that.
my lord.
But from this statement, and he also realized to submit the Chita copy trace map of that area for that period of time. Now, if that be so, how can we determine your situs of your possession?
My lord, it was,
There has to be something,
yes, yes, yes.
because now this has been disputed. That very possession, your only plea is from 1962, at least 75, 76, page 19. Chita, my name is there with my landlord.
My landlord, yes,
So where is that land gone?
yes,
So that land is somewhere. That land is not being, you are not evicted from that land
okay,
by this paragraph.
okay. My lord, at the time of creation of this land,
Hmm.
in the name of Majumuddin Ahmad, that is the, I am the Husnul Reddy also, so where if I am the tenant and I am the Rayat of those gentlemen, where my name is shown by the
So
government.
if your name is excluded from that Chita at that point of time,
Yes,
you have to take steps to get yourself included there.
but my lord, how? How, my lord, when I shall have to get a notice from the government that your land is not this one, your land is somewhere else. But when the patta was issued in the name of the Hasnur Ali, at that time Dag number and patta number was there, and wherein, my lord, I have been shown as the Rayat. Now
So
preparation.
your stand is the description of your status in the Chita from 62, at least 75, 76 in the at page 19.
Yes.
Okay.
Yes. Or my lord, I would like to submit otherwise also that the patta which was issued to Hasnur Ali in the year 1960, my lord, or even prior to
Have you
that,
made the has a party here? Your landlord, is he a party here?
No, my lord. My landlord is not made party.
Because
Because
if they
there
were
was-
a party, they could have clarified.
There was no dispute. There was no dispute with them.
But after this paragraph,
My lord, that's why what I would like to submit before your lordship, let there be a verification from the side of the government that where is that land which was allotted.
we'll
in
hear
the year
Mr. Hazarika on that,
Yes.
Mr. Borpujari on that, and then come. We'll do that. Yes, now proceed. So he says, because this aspect was not placed before him, in that letter is, he does not say in so many words, that is redundant.
Yes, ma'am. That's what it is.
Okay. So you have filed a reply.
Yes, my lord.
Now, where have you dealt with this paragraph?
My lord.
Reply affidavit to us.
We have also given a reply to those two affidavits. my lord.
mm.
Yes, my lord, paragraph number 6 onwards are more relevant, my lord. Or if I can take your lordship to the entire this affidavit.
No, you can take me from para 5 clause 1. There is no dispute or question regarding title and
That-
ownership of so-and-so, where I have claimed my tenancy right after demise of my father over 771 Pasim Buragan so-and-so. That being a recorded tenant so-and-so have been so-and-so.
Paragraph number 6, my lord.
Hmm.
That I hereby state that the land for construction of judicial court allotted by the government of Assam by letter number so and so dated so and so, where it is stated that a land.
Where are you reading?
Paragraph number 6, internal page 3, my lord.
Of your reply. Of
That
your
is-
reply.
That is of my reply, my lord.
2011.
Petition.
Paragraph 6 is something else. The chitta submitted by the respondent number so and so, Doug number so and so, Pasim does not reveal its corresponding old patta and same is required to be submitted in detail as called for by this court.
My lord, that my affidavit is.
2011.
Yes, 22.
2011-2023. It starts with I beg to state
Yes, my lord.
that I am the petitioner. 1.
It is.
2. I have gone through the affidavit dated 18/9 and 29/2023. Right?
Yes, my lord.
Then
Then thereafter, while para number 3, that while perusing.
perusing, yes. Then 4 is that I have both the statements of both the statements of respondent number 2 or not gives an impression of non-application of mine.
Yes.
Right? That during the course of hearing of the instant writ petition and as per direction, all the records such as so-and-so were required to be placed. Then there is no disputes. Then you have explained that paragraphs. No
Yes,
dispute or question.
Yes, there is no dispute on question regarding title and ownership of.
Then 3. Then
Then 3
4.
is that the draft chitta of the year
Okay.
1957-64.
Then 6 of that subpara. You are reading 6 of that subpara.
Yes, my lord.
That is at okay. I say that I have rightly claimed.
That I say that I have rightly claimed my ownership right as per the Khatian and in respect of the schedule as mentioned by me in the instant writ petition, in the writ proceeding. The schedule which I have mentioned in the instant proceeding is derived from recent and the same is as follows. This is the schedule, my lord. And then, my lord, in again para 6, I mean the alphabetical, that the chitta submitted by the respondent number 4 in respect of Dag number 730 old of so and so of Pachim Budagaon does not reveal its corresponding old patta number, and the same is required to be submitted in detail as called for by this honorable court.
So you want them to bring the preceding Dag numbers
Yes.
pertaining to that plot and then make an idea. Okay. So
Roman
what would your prayers be?
My lord, in the writ petition, my prayer is.
No, you can just submit. What you basing on this, what is your prayer?
To settle the land, my lord. To settle the land because I have already.
Settle the
applied-
land would require an identification of the land also.
My lord. And
Okay,
I am ready to pay, my lord, the 50 times of the.
thing. Yes. As on date, revenue as on date.
The prayers in the writ petition, lordship will find at page 15 of the writ petition. His first prayer is, my lord, for setting aside and questioning the impugned eviction case and the impugned order direction passed therein by the respondent is reflected in impugned notice in eviction case number so and so. And his second prayer is for directing the respondent authorities to settle the scheduled land in favor of the writ petitioners in accordance with the provisions of law in terms of Assam land reform policy adopted by the government. and for directing the respondent authorities to pay adequate compensation.
Mr. Barpujari, for my understanding,
Right.
if the projection of Mr. Sattar
My lord,
in terms of page 19 is taken,
in terms of page 19,
so Hasnur Ali and another, that land they had around 5 bigha odd. He was occupying around 2 bigha something,
3 bigha.
3 bigha, 2 katha under that. So that is also reflected from this sita. That and his name is also entered as a righty.
yes, for that reason, lordship, at page 19, we kindly mark, my lord, on the left-hand side, the dark number is 730. This assumes significance. We are concerned with dark number 704 for the purpose of, my lord.
Now
so-
tell me,
so
what
for-
is the progression of this dark number 730?
Yes,
It became 574.
yes, now
I
that
come to page 19 once.
19.
So you will have to establish the stand of the, what do you call that, the deputy commissioner in the second para,
Yes,
that this land from where he is evicted is not the land he projects under his landlord's 5 bigha something, which is intact.
now,
Right.
yes, now after filing of 2 affidavits by the deputy commissioner, the secretary to the government of Assam Revenue Department has also filed an affidavit.
Where?
Yes, that is the affidavit, my lord, filed in IA. In the IA number 3063. Lordship will kindly take up IA number 3063. This will clear the whole issue. Lordship may kindly take up IA number 3063. This was an IA preferred by them. And in that IA, my lord,
By the joint secretary.
by the joint secretary, the deponent is Syamol Khetra Gogoi.
I got it.
Lordship got it, my lord. Their lordship may kindly come, my lord, to paragraph 4.
Roman 4 or
Numerical 4.
numerical 4? Okay.
Paragraph 4, it will be at page number
I got
14.
it. Yes.
Running page 14. I am reading it, my lord. That in regard to the averments made in paragraph 1, 2, and 3 of the interlocutory application, the deponent denies the same as correct. In this regard, the deponent begs to state as under. Now, this is the fact that the Deputy Secretary to the Government of Assam Revenue Reforms and DM Department, while letter under file number so and so dated 9/1/2023 had requested the Deputy Commissioner Kamrup Metro to provide a specific detailed report as to whether a boundary wall by any person or authority has been constructed over the land in question occupied by the writ petitioner or the land claimed by the petitioner under the tenancy case. That letter, lordship will find, my lord, at my lord, page 20. That is annexer Roman 1. That is dated.
What
9th
was
of
the,
January.
this was in connection with the present case.
Present case. Present case. Because they had filed an interlocutory application, my lord, to bring on record certain, my lord, developments. And for claiming, my lord, that they need not be evicted. Now, my lord, coming back, my lord, to page 15, where I was reading, my lord. Lordship will kindly see, my lord, Roman subparagraph 2 at page 15. Paragraph 1, I have just read it.
Oh, fine, go ahead.
Yes, that pursuant thereto, as per direction of Additional Deputy Commissioner Kamrup Metro, the Circle Officer of Guwahati Revenue Circle caused an inquiry, whereafter he has submitted a report before the Additional Deputy Commissioner Kamrup Metro, by letter dated so and so, as reported by the Additional Deputy Commissioner Kamrup Metro, by letter dated 10/1/23, the boundary wall over the instant plot of land has been constructed by the district judiciary. In the report submitted by the Circle Officer Guwahati, it is clearly mentioned that the petitioner Srimati Bulbuli Borgohai has no possession whatsoever over the plot of land situated at Daz number 730 of KP Potta number 135, situated at Posim Boragao under Jalukbari Moja. That letter, lordship will find.
But that is again contrary to your page 19.
No, my lord, here he speaks about the possession. I'm not going.
Possession because 2014 she was evicted. So
No.
she will not have possession.
Lordship will
Okay,
kindly see, my
Okay,
lord.
okay.
Lordship will kindly see the chain of events.
Hmm.
That as, and now paragraph 3, my lord, that as reported by the additional Deputy Commissioner Kamrup Metro, it is further clarified that as per draft sita of the land measuring 3 bigha 2 kotha under Khatian number 301, covered by DAG number 771/730. Now 771 was the old DAG. Then 730 is the new DAG.
But here, okay, 771 is the new duck, 730 is the old duck.
730 is the new DAG.
But in the certified copy of the Chita
Hello.
at page 20,
Hello.
if you see,
Yes.
it will be 730 is the old, 771 is the new.
Yes. Yes, perhaps, my lord, here there is some typing mistake.
Where?
My lord, in the affidavit,
Okay.
which I am reading.
Okay.
In the year 75, it's 1975-86,
Hmm.
was recorded in the name of Bulbuli Borgohai.
It would be the reverse.
Jalukbai Mona. So the factum of the fact that the name of the petitioner was recorded, my lord, in the year 1975-86, that has been admitted. Now
Hmm.
kindly see, my lord. On the other hand, as per report of the Circle Officer Guwahati Revenue Circle, it is seen that land measuring 802.7 bigha 4 kotha 10 lessa covered by DAG number 704/1688 new is recorded as government land and marked as reserve. Now, this is the quantum of part and parcel of land which the government is disputing.
So you mean to say, even if we take the description 771 as new
Yes,
and 730 as old,
yes,
you would be contending that this is not the land
yes.
belonging to the petitioner. So
Absolutely.
where is the land of the petitioner?
The land of the petitioner, my lord, she will have to be my lord, a tenant occupying and cultivating over.
No, I only want that, where is the further progression after this
Yes,
page
yes.
19?
Let me read, my
Hmm.
lord. So and so is recorded as government land and also marked as reserve
Hmm.
in the remarks column of the Chitha village Paschim Moranga.
Hmm.
It is further reported by the additional Deputy Commissioner Kamrup Metro that the land from where the petitioner was evicted in the year 2014 was from DAG number 704/1688. Under the aforesaid facts and circumstances, the deponent states that the contention of the applicant that she is the recorded tenant in respect of land under DAG number 704 so and so new is not correct as per Chitha as well as report of Circle Officer Guwahati Revenue Circle, and as such the same is denied. It is further denied that the applicant was dispossessed by flouting all command and authority of this honorable court. The deponent also denies and disputes the correctness of the letter dated 6/1/2022. Now this has already been dealt with, as the contents of the same are contrary to record as well as field verification report submitted by the Circle Officer Guwahati Revenue Circle. Then, my lord, I am reading it, my lord, paragraph 5. That with regard to the above within so and so, the deponent denies the same is correct by reiterating and reaffirming the statements made in paragraph 4 of this affidavit in opposition. The deponent states that as reported by the additional Deputy Commissioner Kamrup Metro, the construction of boundary wall was being carried out over a plot of land 59 bighas 4 kotha 10 lessa covered by DAG number 704 old and 1688 new, which is recorded as government land, and the said construction has been carried out by district judiciary, and the applicant petitioner has no possession over the said land. No construction has been done on the land claimed by the applicant under Khatian number 301 covered by DAG number 771/730. Here lies the
Yes,
answer.
Mr. Sata.
Here lies the answer. This.
If these two DAGs are different, just, I'm trying to, maybe a very trivial question, but just give me. Let us say that your landlord's land is also subsumed within that government reserve. It has to be.
Yes, my lord.
They have not raised any objection. That means that land is intact.
My lord, about their raising of objection, I have. nothing
Because
to
see,
say.
the authorities say that the heirs have also been incorporated recently.
Yes.
So that means they literally, we don't know whether they have the possession of the land or not, but on records, they are there. That means there is a land of that description somewhere.
Yes.
So the land from which you were evicted,
Yes.
admittedly, is 704 new, old, and 168 new. Even if
168
we hold that typographical error, we go by 19, page 19.
Yes.
It
Page
would
19,
be
page
70,
19.
730 new, old, 730 old,
old.
and 771 new.
New.
Both different dugs.
Together with my lord 574. 574 at the top of that.
574 has not been brought in the government reserve land.
No, may not be, but my lord, old dag 770 is made two dag, 574 and 771.
Okay,
And
now
that was-
574 is also not included in either 704 or 1688.
Yes, yes. Now, if this page number 19,
So I only have to examine first whether you were evicted from the land under Khatian number 301.
yes,
And the materials that the government have brought in, have you filed a reply to this affidavit?
yes, my lord, I have.
What is your stand?
My lord, at page number 13, to that, my lord, my lord, paragraph number 3 of my reply dated.
Where is the reply to subpara 3 of para 4?
Para 4 is in para number 3 of my reply, my lord. May I read that one, whether your lordship?
So you are referring to that letter of 6/1/22. That is the deputy commissioner's letter,
Yes,
which he says was erroneously made. So we can't place reliance on that. By
There are-
filing an affidavit before this court, he says that's the only ground you have. Otherwise, they have now demarcated the dugs, at least in subpara 3. Clearly.
yes.
Now, where is your thing that no, 7040 and 168 also is that 5 bigger 7? Because the dug of your landlord and yours would be the same. Either.
Yes.
It should be the same.
Must be same.
Must be same. Then,
Must be same, my lord. That's why,
then this is a issue, Mr. Sattar, you will have to go before the civil court.
for that purpose, I have to go to civil court. That is altogether a different aspect, my lord.
But here, we can only record a finding that the land from which you were evicted, as per the stand of the government now, because 6/1/22 we can't, we'll not go into, it's disputed,
Yes,
is not the land under 301 Khatian. I can go to that extent. And then I leave it to you. You go before the civil court, establish your right.
my lord, but before that, my prayer before your lordship is that where is that land which was recorded in my,
That is with the land under possession of your landlords, because that has not been disputed anyway.
my lord, the dag and patta. which-
Yes, Mr. Borpuzari accepted your proposition that this land is not the land where he is 301 Khatian. So if the 301 Khatian land is there, consider
should-
his application.
My application.
This is not
for
the
a
list.
allotment. Yes.
This is not the list before this court. Therefore, Lordship.
No, he has a list.
I have-
He has a list. He has a list to that effect
Lordship,
because he has made a second prayer. Ignore the first prayer.
Lordship, for a moment, Lordship may kindly come to page 70, that affidavit filed by the deputy commissioner. I am troubling my lord with
No.
Yeah.
The writ petition.
writ petition, running page 70. In the writ petition, my lord.
Second affidavit or first affidavit?
My lord, it should be, my lord,
18 or 29?
yes, it should be the second affidavit, my lord. It has been filed by, my lord, the deponent is Pallab Gopal Jha, the deputy commissioner. My lord, lordship will find that running page number 70. Running page number 70.
That is the first affidavit.
Yes,
No. No, the additional affidavit, that is by the petitioner running page.
yes, clarify.
You give me the
Yes,
paragraph number
paragraph number 3. Lordship will find
that the writ petitioner applied for. Is it the writ petitioner has applied to get?
no, my lord, that lordship will find at running page number 69.
No, there is some mistake here.
Yes,
No.
yes. My lord, paragraph number 3, that your deponent begs to state that I have verified the land documents.
1 second. That is the second affidavit, yes.
Second affidavit. In the second affidavit, lordship will see that paragraph number 3. I'm reading it, that your deponent begs to state that lordship has already seen the affidavit filed by the department. Now this affidavit substantiates. Their deponent begs to state that I have verified the land documents, including Sita copies as well as the trace map of the land in question. And it was found that the writ petitioner has applied for granting ownership rights of her plot of land so and so having DAG number 574, 771, 730. Petitioner has stick to this one for a plot of land 3 bigha 2 kotha covered by Rayati Khatian number 301 against KP Potta number 135. No dispute. It is seen that the petitioner was a riot of Khasnur Ali and Sukna Sheikh, who are the landlord of a plot of land measuring 5 bigha 2 kotha 7 lesser. No dispute. Under the same DAG and Potta, after completion of the settlement operation, lordship will kindly mark the DAG number 1763 new and Miyadi Potta number 605 new have been created from DAG number 730 old and Miyadi Potta 130 old of the revenue village.
So this is the DAG wherein the petitioner's land may still exist.
Yes, yes, because the petitioner is claiming secondary rights. Lordship will kindly mark. Petitioner is not claiming primary rights. He is claiming under the landlord. Then lordship will, let me continue, my lord. As per record, the DAG covered 73.29 R, which is 5 bigha 2 kotha 7 lesser. My lord admitted presently Muhammad Muzamuddin Ahmed, son of Sukna, and Gul Muhammad, both her son of Khasnur Ali, Saira Khatun, wife of Muzamuddin, and others are the recorded pottadars of the said potta. They are the landlords. Now this assumes significance. Further, during field verification, I will draw my lord's attention to the relevant provision of law. During field verification, it is found that the writ petitioner had occupied the land covered by DAG number 704, 1688, which is government land. Instead of Rayati Khatian land so and so, the land covered by DAG number 704 measuring so and so is government land, and the said plot of land is already reserved for construction of family court, and the petitioner was evicted from the same government land way back in the year 2000. So on papers it is something, and on field it is something. On papers he is claiming secondary rights. There are landlords. He is claiming tenancy rights. Under
The projection made by you, the land under the landlord is intact.
intact.
So if she is there, she gets it. As per
Landlord-
301 Khatian.
Landlords are not party respondents before the honorable court. Matter ends. Now, we have laid out a clear case. Now, it is not his case, my lord, that there's a DAG number 704 old, or for that matter, 1688 new,
Is 730.
has to be de-reserved and allotted to him. He is not
My lord,
making a prayer for turning the clock back.
Yes.
one submission before your lordship.
Hmm.
They say that patta number, Kharajbazi patta number 605 is created during the settlement operation. Where from? When they are already showing that DAG number 730 old is now 1763 new, then patta number, my lord, 605, where from it has come? Because my patta was 135.
That they have written has been created from DAG number so and so and Miyadi Patta number so and so.
Miyadi patta number 605 is
Created from 135.
Not that, my lord. May I read, my lord, that paragraph which he has already read? That your deponent begs to state that I have paragraph number 3, my lord. Verified the land documents, including chitta copies as well as the trace map of the land in question, and it was found that the writ petitioner has applied for granting of ownership right over a plot of Rayati land under Moja Jalukbadi village, Pachim Buragam, having DAG number 574, 771, and 730. My lord, that is,
This is
Yes.
730 is old, 771 was new.
yes. For a plot of land measuring 3 bigha 4 katha covered by Rayati Khatian number 301 against KP Patta number 135. It is seen that the petitioner was a riot of Khasnur Ali and Sukna Sheikh, who are the landlord of a plot of land measuring 5 bigha 2 katha 7 lecha under the same DAG and Patta. After completion of the settlement operation, My lord, my settlement operation was in the year 1956-57.
No, there may be a fresh settlement operation.
Maybe, my lord, but then they shall have to, they are duty bound to show that the old dag and patta which was existing in the year 1957-58, now it is changed to so.
That is what they are saying
Yes, I'm
after
coming to-
completion.
I'm coming to that, my lord. I'm coming to that. After completion of settlement operation, but which year settlement operation they are not speaking of.
Let us
After
go ahead.
completion of the
Dag
settlement-
number so and so,
Dag number 1763 new
new.
and Miadi Patta number 605 new have been created from Dag number 730
Old.
and Miadi Patta number 135. But it is not shown, my lord.
That,
It is not shown.
you have not disputed this in your reply also. You have not disputed that in the reply.
Yes, then I may be, ownership may be given to in respect of Patta number 135, which is now
135 now has been converted
to 60.
605 new.
Yes, my lord.
You establish your right under 605, Dag number 1763 new in a manner known to law. Take the land.
No, my lord, I was there. It is there to show that.
Mr. Sattar, the projection made by you was, see, this is the 301 Khatian, 730, 135 Patta. I am holding a Rayati, registered Rayati.
Yes, my lord.
So I have been evicted.
Yes.
The deputy commissioner made some mistake. Maybe that we will ignore.
Such an authority has made a mistake.
He may be projected.
Yes.
Somebody may have projected that matter before him. Be that we give him that long rope. So that 6122 which you claim is gone because 6122 letter requires the government to de-reserve the reservation made in favor of government and give it back to you.
Yes, my lord.
So that is gone. Now we have that the land wherein your Dag Patta Rayati is there.
True, my lord.
It is after settlement, it is continuing with the landowner. That parcel of land is continuing. There is no change in the parcel.
Yes, no. Shall not be also.
Now, when they kept this Dag separate, they had reserved certain Dags under government land, as government land. So when they wanted to reserve it for a government institution, they found that you are occupying a part of that land. 1 katha, 2 katha, whatever it is. They evicted you. You come up before this court.
Not from 1 katha, but from that 3 bighas.
No, you come up before this court.
Yes, my lord.
You come up before this court says status quo. Now the dispute starts. They have now clarified that the Dag where we have undertaken the eviction process is not the Dag flowing from 730. It's different. If that is the position, the eviction is perfect because you don't have any right over
that.
any other land other than that flowing from 730.
True. True, my lord. Then, my lord, 135, if according to them is.
135 is now converted to 605.
605.
So it is intact.
Yes.
You assert your right with regard to 1763 new, Khatian 301, 730, 1763 new and Miadi Patti 60. Assert your right.
My lord, I am given Khatian. I have been.
Mr.
My
Sattar,
lord,
the
I have
projection
been-
that has been made, that
Yes.
Khatian is intact. It has not
Yes.
been touched.
So I have been given Khatian under Patta number.
We will
130.
provide for that. We will provide for that. If you have the right, if that Khatian
Yes.
from 730 converted to 176.3 Miadi, they will make an inquiry. And in the inquiry, if it is found that yes, you are possessing a land under that landlord, in terms of that 1975-76 Chita register,
My lord.
they will consider your case. That
So they will,
Even that,
will
even that
give
may
me-
not be, even that may not be permissible because of the simple fact, my lord, that, my lord, we assume that these are two contiguous plot of land. Now 70, so far as 70.
no, I'm not on that. If he is not occupying a plot of land under that,
No, my lord, I am going little further beyond that. Now, lordship will kindly mark here, my lord, that the petitioner is a tenant, recorded tenant. He do not have any primary rights over the land. If at all the person, if someone becomes aggrieved by the change in the nature or character of land, maybe, my lord, assuming for the sake of this matter, my lord, that the original, my lord, that Khatian has been changed, Dag number changed, Patta number, which he is now disputing. he is claiming secondary rights. The primary persons who will be affected will be the landlords.
No, Mr. Varpuzari,
Lordship,
in
I
this
say-
case, the land of the original landlord, 5 bigger odd, is not disputed. It's continuing with that landlord. Your case is simple, that maybe she was occupying a plot of land in 704, which admittedly is not a derivative of 730,
Absolutely.
and accordingly you had conducted an eviction.
Yes.
So that means she has been ousted from this land. No problem. Now, if she continues to have a possession or a right in regard to 1763 new and Miadipatta number 605N of now the heirs of the original landlords, that right cannot be
Yes.
taken away.
Yes, so for that reason, it will be a lease between the tenant and the landlord. This is what my lord section 23 and 24 of the 1971 Act provides.
Sure, that.
Yes, she will have to make a fresh, my lord, application before the deputy commissioner.
That's what I'm saying. She
Yes.
can still assert her right.
Yes, so therefore lordship may not be pleased to issue any direction to the government in this proceeding.
No, I'll give her a liberty.
Yes. It
I'll
will be
give her a
open
liberty.
second course.
I'll only say that
Yes.
the government has, by way of an affidavit,
Yes.
shown
Yes.
that the dark which was used for the government institution
Yes,
admittedly is not a dark flowing from 730.
absolutely.
So any right that subsists to the petitioner under 730, which is now converted to 1763,
The petitioner.
1763, the petitioner has liberty to assert that right before the competent, in the competent authority, before the competent.
I'm so obliged. I'm so obliged.
That's all. What more is there?
Lordship, for a moment, lordship may kindly
23,
see, my
24.
lord, that 1971 Act.
Hmm.
There, lordship may kindly come to.
Very, very interesting, Mr. Satta. I know why you enjoy your profession, your practice. Now I am learning it, what I missed out.
Both of.
My lord, one thing is required to
Both of-
mention that in the affidavit, they have mentioned that 135 patta is converted to.
To 605.
Yes, ma'am.
And you assert your right in
Yes, my
that.
lord, that much one.
Yes. What do you want?
Yes, because
Section?
the record doesn't show that 605 is converted. from-
That we will go
Yes,
by the
That
affidavit.
is from the affidavit. only.
23, yes. And that is from records, they say. I've
Yes, my lord,
verified.
It is from record.
It's from records, they have verified that.
My lord.
Yes.
I must fairly admit, this is the beauty of Satta, sir.
Huh.
No, he can transform a writ proceeding into the nature of a civil proceeding, civil suit.
I
It is in that manner.
I look up to him a lot. I know. I had an occasion only once or twice to appear against him.
Yes.
And you don't know how much I had to struggle the 2 nights before that. Because you don't know where he will come out with something. But I could not finish one. We were enjoying that. It was an appeal before the RERA. But unfortunately, I could not. I was instigating him to get out, but the man, cool man that he is, he was always cool.
I'm so obliged.
23.
My lordship, before that, lordship may kindly see section 21.
Okay.
Section 21, 21, 22, 23. 21, may I read it, my lord?
Hmm.
Acquisition of ownership rights and intermediary rights by the tenants, notwithstanding anything contrary to any law, custom, or agreement, and occupancy tenant personally cultivating the land of his tenancy shall be entitled to acquire the rights, titles, and interests of his landlord hereinafter, called the ownership rights according to the provisions of section 23(1). Provided that where the holding of an occupancy tenant is being cultivated by an under tenant, this is not, my lord,
11.
required here, then lordship will kindly see, my lord, section 22. The state government may at any time after the commencement of this act by notification declare that the rights, title, and interests of all the landlords in respect of any holding held and personally cultivated by occupancy tenants shall stand transferred and vested in the respective occupancy tenants free from all encumbrances created by the landlords. The rights, title, and interests all by of any or all landlords in respect of any holding held by occupancy tenant or non-occupancy tenant, so and so, from the date prior to the commencement of this act. So this gives a minor deeming provision. Now, section 23. acquisition of ownership rights and intermediary rights by tenants. An occupancy tenant
Right.
personally cultivating the land of his tenancy, desirous of acquiring the ownership rights of his landlord, may at any time make an application in writing to the deputy commissioner, and on such application being made, and compensation as provided in section 25 is determined and paid by the occupancy tenant, the deputy commissioner shall declare the said occupancy tenant to have acquired the ownership rights free from all the encumbrances. So he will have to make an application before the deputy commissioner, and in that proceeding, my lord, the landlords are the necessary parties.
I think there was an application made.
Yes, my lord.
Yes, they had made an application. And it is with regard to this, my lord, miscommunication or misconception, whatever we call it, my lord, that the deputy commissioner had issued that in an impugn letter dated, my lord, 6/1/2022, which he now disowns, my lord, by filing the subsequent.
Mr.
affidavit.
Sattar, if you can come to page 28 of your writ petition.
My lord.
This confusion between 771 and 730 is there also. Page schedule of the land.
Schedule of the land, a plot of land measuring 3 bigha, 2 katta, my lord.
Hmm.
2
Covered
katta,
by DAG number
771,
574 old
574.
and 730 new.
New.
Whereas in page 19 is the reverse.
Page-
730, page 19. If you can come to page 19,
Yes, my lord, 730.
is old.
In the, yes, in the next column, my lord,
New 771, 574.
574.
So both you as well as the government, subject to correction, has been projecting 730 as new, 771 as old. So it's not a mistake of the government. You also have committed that.
My lord, that I have quoted from here itself. That I have quoted
Okay.
from my,
Okay, nothing more. This is the final conclusion.
Yes, ma'am.
We'll remand back. Eviction, we say, is proper. So contempt gone.
eviction is not proper.
No, eviction, as per this thing, is from 704.
As per the recent settlement operation.
704. So
Yes.
that is okay.
Yes.
But in terms of the government's own affidavit,
Affidavit, yes, my
it
lord.
says that Khatian number 301, 730, 771
Yes,
converted to 1763 and 605
605.
yes,
new. That is a subsisting land under the landlords, the
Yes.
heirs of its landlords. So if you have any grievance with regard to settlement, you can exercise the powers, the liberty given to you under section 23 of the Act
absolutely.
and submit an application.
True.
The Deputy Commissioner, on considering your application, after hearing the original landlords, will pass appropriate
My
orders.
lord. But my lord, that 135 patta is required to be mentioned.
135 converted to 70605. But I'll only request both of you to give me a short note in this line.
Yes, ma'am. Yes,
Tomorrow,
tomorrow.
day after.
Day after.
I'll forget otherwise.
Day after.
Day after. We'll list it day after. So give me the note, I'll pass the orders. So that I don't miss on any facts.
My lord, my learned friend will be giving. I-
Please, anybody, I will record your name. I've heard you. You're only required for hearing, not for writing. Mr. Barpujari, just
My lord, my lord.
flow it as
Yes,
we have
yes,
discussed.
my lord.
Thank you.
I'm
We'll
so
dispose
obliged.
all the three on
My
Thursday.
lord.
I'm so obliged.
Heard the learned counsel for the parties. Hearing concluded, the learned counsels, the respective, the learned parties are granted liberty to bring on record their respective written arguments by 8/8/2024. Accordingly, registered to list this matter for on 8/8/24 for delivery of orders. List this matter on 9/8/24 for delivery. You kindly give it by Thursday.
My lord,
Thursday.
I'm obliged.
Ajay, 7 to 42.
My lord,
If I don't write it, I'll forget. It will file to format it.
my lord, most of the government advocates are not able to
Come
come
today.
today, my lord, so as to take care, my lord, any date, my lord.
But this
as
case,
my
I somehow it's being very slippery. We'll not allow it to go any further.
lordship, we are.
We
reading
accept
record.
your proposition that Mr. Bhuya's petition is full of contradictions and disputed facts. But on perusal of the material, there is a latest decision of the Supreme Court.
Yes.
If the court, on the basis of the affidavits, can come to a conclusion, then those decisions in the earlier cases, disputed questions will not come in.
Lordship.
Here, I find only one thing. Whether he was required to broadcast 12 commercials or six
Six.
commercials.
Lordship.
And the director, his communication is there, wherein he says, after much water has flown down, that see, I have completed the other 6 also. I'm ready to give, but there is nothing to show that the government had actually taken it. If that be so, coupled with the fact that you had subsequently cleared 63 lakhs in your files, but the director changed and then nothing happened. In this small campus, you can't go beyond your agreement. Now you can't ask him that give me the clips where you have aired. NDTV and all those other television channels to which they have given their bills. You should have made an inquiry, or you should have entrusted someone in your office to sit before the TV and watch.
Lordship.
So this is the narrow compass.
Absolutely. My lord, the record will be very much necessary. Why I'm so insisting.
I don't want any other records. I want the records wherein the bills of the petitioner was processed and cleared and not paid.
And apart from that, the note sheets will reveal everything because this honorable court allowed me to see the record. And from the affidavit, I have note down the page number also, 11C, 11D.
In the affidavit, I have seen 11C, 18C. Then what are those?
They verified everything.
But those are confusing. It's only 11C written. What is in 11C is not there.
That's been quoted also in the affidavit.
Your affidavit.
Yes, in
Okay,
replies.
I missed out.
In my replies, I've quoted that they have verified everything with regard to telecast certificate.
So that is the only area of dispute.
With regard to supply of 6.
I am still ready
Lordship.
to push Mr. Bhuya back to the civil court, provided you show me this.
And
clarify.
the records are available with him, my lord.
You get the records.
Any date, my lord.
When?
as per-
Tomorrow, day after? Whenever it's convenient. Mr. Bhuya is a busy man, so we'll have to give him some leeway.
My lord. It's been a first opportunity, my lord,
I'm
to argue a matter. So they are seeking, my lord.
I'm happy that I've seen you here.
14 or 15, my lord.
15th, we will have it in the
14.
field.
13 or 14, my lord. 13 or 14, any day.
14, no problem.
Lordship.
Hmm?
Lordship.
And with
So
the-
that is the only area.
My lord, can we see one thing also in
Yes.
record? 6 DVD and 12 DVD.
Hmm.
In the note sheet, it's been reflected that I have been given 6 DVD, which I have telecasted, for which I have raised the bill.
No, the balance 6,
Yes.
I'll not take the name of the director. His letter
Yes. And
that I am with him, with me, and that was never taken from him by you. How will he get it?
absolutely.
Some
And my lord
lapses
will kindly
were
see on the last occasion when it came up before Honorable Justice, yes, the question was that he has raised the bill, whatever has been shown. What has not been telecast has not been raised.
Not been raised. And there is no allegation to that expectancy. Your case is, he has not telecasted 12. But he has telecasted 6, give him that bill.
Absolutely.
And the bills are below the agreed rate. Agreed rate
Absolutely,
is
absolutely.
above
3,78,000 was this, we raised 3,22,000.
22.
Whatever we shown.
Lordship.
And all bills are corresponding. I've just casually checked up. That is for you to check up. Corresponding bills of the of the, what do you call that? The telecasters,
Yes,
are they?
these are reputed, my lord.
You can take a plea that all those bills have been forged by Mr. Then you file a CBI case and then go ahead. Yeah.
Yeah.
Lordship.
But if those bills have been accepted to be
Exactly.
correct, finished.
He's
right.
supposed to.
So
get
it's
those
not a
amount.
prima facie, it's not a case of disputed questions.
Absolutely.
It's a projection of disputed questions, which we will not accept.
Lordship, record with
Try to
everything.
get
Yes,
hold of
I-
that
if
decision.
my Earlier judgment.
No,
was
no,
the
no,
same
no.
thing.
Recent
judgment.
recent
I will.
judgment.
Deeply obliged for that.
Same, following everything that,
Yes.
no, I think I'll have it somewhere. If I get it, I'll get it.
Yes,
So when? 16th, 14th, when?
13, 14.
14.
Lordship,
Will it be possible?
Lordship, because he will be available, but today, my lord, because of my lord.
On the prayer of the heard the learned counsel for the parties, as prayed for, at some length, full stop, as prayed for, list this matter again on 14/8/2024, on which date Ms. U. Sharma, additional senior government
My
advocate.
lord, I'm not, Mr. D. Nathwil,
You are there appearing on behalf of Mr. D. Nath,
No.
learned senior government advocate, shall ensure that the contemporaneous records, including the records wherein the bills of the petitioners were processed for payment, shall be placed before this court without fail. Full stop. As prayed for, list this matter on so and so. Huh? So and so.
Yes, deeply obliged for. Deeply.
Obliged, my lord.
Try to get that judgment.
Yes.
May it please the lordship. The matter pertains to the non-payment of compensation, which has been done during a seismic survey blasting by ONGC. On the last occasion, lordship, this honorable court was pleased to allow me to file an IA, and accordingly, respondent number 6 has been impleted. And
Who is respondent number 6?
the contractor.
Okay.
Malab, I'm respondent number 6, ma'am.
Okay.
Malab, we are appearing for the first time.
You're welcome.
Sure, Malab.
Now you can take your seat.
Yes, Malab.
Yes. Show me, how will I determine?
Lordship,
There was some blasting.
Yes.
2 months you had not raised any objection. Thereafter you started raising. And in that area, other than your house, I have found from the list annex, there is no other person making such similar complaints. So establish that in the civil court. How can we here? I don't have the, in Mahabharata, there is a person who can see the battle sitting here. I don't have that.
The
Lordship,
person is Sanjay in Mahabharata.
we have filed a representation before the DC. And
DC will not do. You will have to go before the civil suit. Establish that this is the damage caused on account of the seismic activity, and thereafter proceed.
the circle officer has
Circle officers, that's just a presumptive deduction made. There is no material on what basis he has come to that conclusion. Because I can't come to a conclusion here on the basis of the affidavits that yes, because of that seismic activity generating the blasts they have used led to cracks being developed. Because in that area, your house is not the only one. There are many other houses.
Lordship.
Where are the others? Nobody has come up. So this activity cannot be specific because this is not splinters going, right? Splinters don't go out. It is they drill a hole, they put in explosives, they blast it, and then they take readings to know what is the, how much oil, if there is oil, what is the mapping, what is the land,
Lordship.
what is the topographic, geological examination.
Lordship.
From there, splinters don't go out. Normally, a bomb blast, splinters go out. So here, your house is affected because of the seismic activity
Lordship.
or the sound, whatever it is. Now, if that be so, how can only your house specific be affected the others? In that area, any other house?
There is other house, but no one has complained.
Other houses are there.
In the same area?
Same area,
Yes.
but only one person has been
Before your lordship. No. Any other house wherein such cracks have developed.
No intimation is there.
Because if you see an affidavit here, your house is, you come to page 40, running page 40. Sheikh Ahmed Hussain, right?
Lordship.
Desang Ghat. Hatonipar, Moza, Bedbari, District, Sipsagar. You find out if there is any other person of the same village here, you won't find it.
Lordship may give me some time to find out if some other person have.
With this material, we cannot. I'll give you, if I have to dismiss it, I'll have to record everything. I'll not do that. You think over it, withdraw it. I'll give you liberty to go before the civil court, delay, condone. You get it on evidences, get evidences on record, and then determine the compensation.
Sometime in.
I'll give it you time till 2 o'clock.
Okay.
Mr. Sharma, anything you want to say?
My lord. this is
We'll
what-
saddle you with the responsibility. You have done it. You
My lord,
claim it from him.
My lord, there is no evidence that prove that we have we have done the.
You have done it. You have done it carelessly. That is why this has happened.
My lord, if we have done the carelessly, then the PWD and the other person should be appointed to examine and all, and that should be done before the district court. He should let evidence for damages, because even the writ petition.
But you wanted to file an affidavit now.
No, I
Don't
never
have
said
to
that.
file-
I said that I want to appeal. I am appealing for the person also. That's all.
Item 13.
Yes.
Yes, my lord.
How are you? A long time.
Yes, my lord. I'm fine, my lord. Thank you. My lord, I am agreed by an order that was passed by the executive magistrate, my lord, that has not been complied with, my lord.
Complied with.
Yes, my lord, there was a direction to the officer and the circle officer concerned, my lord, to, that is lordship finds at page number 18, annexure 2 of.
That has been done with.
Not has done, my lord. I have filed several representations also, my lord. The respondent number 5, he has filed a criminal revision against that order.
What happened to that criminal revision?
Pending no stay as we have appeared.
So if that order goes, your established right also goes. Your right is flowing from the executive magistrate's order.
Yes.
So if the criminal revision is taken to its logical conclusion,
Well, what I will be praying by, because I don't have any access to my house presently, though I am.
no, that was
Other-
given. That was
Yes,
given. That is now under consideration of the.
If I am permitted, my lord, I may give an undertaking that if that proceeding in criminal revision goes against me, I will, my lord, do it. But
No.
that undertaking is accepted.
That we will not. Because you have, the only prayer is act upon the learned executive magistrate Goalpara's order.
Yes.
Is there a stay order in the criminal? No.
Stay
They have
on
filed
it.
their affidavit, they also admitted.
I am for the response, private.
What happened to the criminal revision?
My lord, a criminal division petition has been filed in fact.
I know that. What happened to
Has
that?
not been, stay order has not been granted.
Then,
My lord, only thing, my lord,
Oh, this one.
only thing, my lord, lordship, kindly see, executive magistrate has passed an order. My lord, that order has been in fact challenged before learned session judge. Stay order has not been passed. Rightly or wrongly, an order has been passed by the executive magistrate. How it should be executed now? Now, my learned friend has filed this writ petition. My lord, I think, my lord, your lordship kindly see the section of criminal procedure code.
so,
My lord, they have filed an proceeding under section 133 CRPC. My lord, order has been passed under section 147 CRPC. My lord, that may be, my lord. My lord, now the order how to be executed. My lord, your lordship kindly see section 134.
CRPC.
134. My lord, prior to that, my lord, the dispute between two brothers. Dispute between two brothers, my lord.
In pursuance to a family settlement.
Yes, my lord. My lord, they are residing in a particular plot of land. amicably settle this plot for this brother, that plot for that brother. They are amicably decided the plot. And my lord, dispute my lord with a private my lord path my lord. My lord, in fact, that private path they are using and we are also using, that has not been blocked. My lord, I am agree. If that particular path has been blocked, that may be removed. I am agree with that portion. My
Yes,
lord.
my
My
lord, that may be removed.
prior to that, my lord, you lordship kindly see CRPC, my lord, 134 section. May I read, my lord?
One 30.
134. Service of notification of order. May I read, my lord? The order shall, if practicable, be served.
Now,
above
this will not come in because you have already filed an appeal against that. So you know about the order. This is only for notice purpose.
My lord,
You know
notice-
about it.
My lord, if my lord, then my lord, your lordship, subpara 2, my lord, if such order cannot be served, my lord, it is notice purpose.
Mr. Counsel, this is only for to bring that notice to the person who is to comply with it. Now you know it, that's why you have filed an appeal.
Yes.
So you know, you have knowledge,
Yes,
so
yes,
134
I
will not
have
come.
knowledge, my lord, that part, my lord, that part has not been, my lord.
So
executed.
you are ready to remove the, you are ready to
My lord,
comply
my
with the,
submission, my lord, my humble submission.
you comply with the order of the executive magistrate,
My lord,
subject to final orders of the
my lord,
criminal court.
my lord.
In fact, there was an order by this honorable court, my lord, earlier in this proceeding itself on 3/5/2024.
25.
3/5, 3rd of May. Even that has also not been, nothing has been done thereafter.
35.
3/5/24. My lord, this is Etihad process.
Okay. We'll record his. From
Yes,
today
sir.
onwards, you use it in terms of the directions passed by the
Executive.
executive magistrate, strictly in, because the blockage will be removed by him. You will pay for that,
Yes, my lord. And
right? And thereafter, this order would be subject to the criminal revision that is pending.
my lord, may I just, my lord, if possible, my lord, concerned OC will also be directed, if he is not removed, my lord, to give a report.
You file a contempt, we will haul him.
Yes, my lord.
Heard Mr. T.R. Sharma, learned counsel for the petitioner. Also heard MS.
A Manna.
No, you does learned additional senior government advocate appearing for,
1, 2, 3, 4. Please for 5.
appearing for the respond numbers 1, 2, 3, and 4, and also Mr. A. Manaf, learned counsel appearing for the respond number 5. The present proceedings have been instituted by the petitioner, praying for a direction upon the respondents number 3 and 4 for implementation of the order as passed, order dated 11/7/2023, passed by the what is it? Executive Magistrate
Executive magistrate.
Gwalpara in miss case number 148/2022 under section 107/133 CRPC, requiring the respondent number
5 he is, sir.
5 herein to remove the obstruction, that is the grate installed by him over the path which is used by the petitioners herein, petitioner or petitioners?
Petitioner.
Petitioners
Petitioner.
herein for ingress and egress to their property. Full stop. Being aggrieved by the said order dated 11/7/2023, the private respondent number 5 herein had instituted criminal revision case number, criminal motion. It's called criminal motion revision case number, criminal revision petition number 20 1/2023 before the Court of the Learned Additional Session Judge at Golpara. Also, in the bar, it is stated that the proceedings in the said criminal revision petition is as on date pending disposal. Also, the parties to the present proceedings have arrived at an agreement that the respondent number 5 would comply with the directions as passed by the executive magistrate wide order dated 11/7/2023, strictly in the manner as it has been so directed, and the petitioners herein shall bear the cost for dismantling such obstruction which is in the form of a gate.
Yes.
Full stop. The parties have also agreed that such a compliance would be without prejudice to the rights, to their rights as rights in connection, rights under consideration in criminal revision petition number 21/2023, and such action now taken would be subject to further orders that would be passed in criminal revision petition case number 21/2023. Also, in view of the said agreement arrived at by and between the parties, also this court hereby requires the respondent number 5 herein to remove the obstruction so existing in terms of the directions passed by the executive magistrate wide order dated 11/7/2023 in miss case number 148, executive magistrate Golpara Likhiba, in miss case number 148/2022, and strictly in accordance with the thereof, and the cost of such dismantling and the cost of dismantling the obstruction would be borne by the petitioners herein. Also, it is also provided the said exercise shall be initiated and completed by the respondent number 5 on due payment from the petitioners herein within a period of 15 days from today. Right? Also, it is observed that the said action, said dismantling as done by the, that would be done in the matter in terms of the done in the matter by the respondent number 5 of the obstruction in question shall be subject to further orders that would be passed in the criminal revision case number 21/23. In other words, the dismantling of the obstruction is without, by the petitioner, is without prejudice to his rights as raised in criminal revision case number, petition case number 21/23. With the above observations and directions, the petition stands disposed of.
I'm obliged.
Yeah, subject to correction, my lordship has observed that agreement between the
Petitioners and respondent number 5. Agreement between the parties, questioner, between the petitioners and the respondent number 5.
deeply obliged.
Obliged.
Item 14.
Yes, yes, Mr. Chaudhary. Your affidavit has not come on record. Why?
Lordship, here the earlier instruction that we received, it was some clarification were required. We received it today itself, Lordship.
Mr. Counsel,
it took some
the
time.
authorities have not yet filed their response. I'm sorry, we are having some problem.
May I make just one submission?
Yes, please do so.
Lordships have issued a notice. After that, the matter had come up again. They are doing short time. Today also not they are filing. The Lordships may just make one submission. This is my refund which is pending with them.
Counsel, I'm not getting you.
2004.
Huh? Sound toll already.
My refund is pending since 2004.
I know, I've seen it. Your refunds are for a period from 93, 94 onwards. But that is there
94
from 2000, assessment
onwards.
orders are from 2003 onwards.
Lordship, so 3, 4 assessment orders are there. There is a sanction by the commissioner also. They are not implementing it.
We'll give them
Lordship,
one
may I
final
just-
chance.
I'm in my lord's hands.
Mr. Ramchandani, we'll give him one final chance.
Lordship.
If they don't file the affidavit by the next date, we will proceed and consider the matter basing on the record materials available on record. Fine.
Lordship, I'll be obliged. I'll
B. Chaudhary, learned counsel for the respondent, submits that although he had undertaken to file the affidavit within 2 weeks on the last date of listing. However, on account of the fact that the instructions received were not clear, the revised instructions have been received by him today. He undertakes that he would file the affidavit on or before 28/2024. So, in the event the said affidavit is not filed, the respondents would not be granted any further adjournment for the purpose, and on the next date of listing, the matter would be taken up for final disposal basing on the material already brought on record. So, list this matter again on 27/8/2024 for admissions. If they don't do it, we will go for hearing on that day.
Lordship, I'm obliged. I'm obliged.
Thank you.
Great, great.
In this case, the state of Assam is the petitioner, and we are yet to receive the counter affidavit.
Mr. Last occasion,
Yes, I'm appealing
I
on
think
behalf of
service is
Mr.
complete and we are
Piketty.
appealing.
I am appealing on behalf of Mr. Piketty, who is appealing on behalf of 2, 4, 5, and 6. So the affidavit is ready. 10 days time to file the affidavit. The
Mr.
person.
Chaudhary, you are appearing for?
Actually, we are appearing for respondent number 8, my lord. We got ourselves implemented in this proceeding.
Okay.
PETA, my lord.
Okay, PETA.
My lord, I have a small prayer, my lord. Otherwise, I'm not objecting to the prayer for adjournment. Now, what had happened, my lord? Initially, Tripura High Court constituted a high court committee. Subsequently, my lord, Honorable Supreme Court, by an order, has given a pan-India jurisdiction. Now, I think that order of the Honorable Supreme Court is on record, my lord. If your lordship would kindly have
I
that.
found it somewhere. Yes.
It's, my lord, WPC 1212 of 21.
Yes, Mr. Chaudhary, you can make
I
your
think the
submissions.
whole matter can be referred to that committee, subject to what my other
Let them
colleagues may
because
say, my lord.
we
Please
have.
come to my lord, page 4 of that order. And you
By
see,
division
by a
bench so-and-so.
judgment dated so and so, a division bench of the High Court of Tripura constituted a high-powered committee consisting of the following. Then my lord will kindly come to page number 8. Towards the bottom. Expanded the remit of the committee constituted by High Court of Tripura to confer a pan-India status. Now please come to para 5. Mr. Gopal Shankar Narayanan, Senior Counsel, submitted remit of the HPC should also cover the following aspects. Now please come to 3 and 4, 5, my lord. Monitoring of the health and age of the elephant, need to shift the elephant. So, my lord, these are the subject matter of the present petition.
Because the state of Assam wants it back.
Yes.
We want it back, let the affidavit be filed.
I-
We will consider everything. And
No,
it is our
I'll wait for the
petition.
affidavit,
We
but
make all our
Mr.
papers.
Soikia, what is the health status of the Joymala as on date?
As on date, we do not have any information.
Yes, what is your information?
I have no information.
We'll require a status on her health also.
Okay. That will be required. That part also.
I hope after the hue and cry, she's
No, my lord,
Kept in a-
according to us, it's not.
not.
My lord, my only submission is since a specialized body has
We
been
will do it.
constituted.
We'll give them one opportunity and thereafter we'll remit the matter. And if we allow the committee to look into it,
Yes.
we can keep this matter pending. Can we send this
Of
to
course,
the
that
committee?
also can be done.
Let the matter be finally stopped.
Okay.
In this.
I think it will be better if your lordship remit the matter to the committee.
When can you file the affidavit?
10 days time. If the person is coming, we'll be doing it.
Mr. D. Soikia,
And lordship may also
additional.
seek the status.
I'll do that. A
And
status
in
report
the
got given
meantime-
by,
prayer, on my prayer.
this
State
one.
of Tamil Nadu would ensure, my lord, proper medical
I'll
facilities.
put that,
Yes.
I'll put that. Mr.
Hello.
Arjay Das, Learned Counsel, appearing for the
Over.
respondent's number.
On behalf of Mr. PKT, right?
No, you're appearing for respondent number
2 to 6.
2 to 6. That is the authorities of the government of Tamil Nadu. Submits that the affidavit on behalf of the said respondents in the matter would be filed on or before
ইয়াতে এখন voting calendar দিবাচোন।
16/8. Will do?
Yes, Lord.
Can you file it within 16?
Yes, yes.
16/8/2024. Also. But Mr. D. Segia, additional Learned Advocate General, State of Assam, assisted by Ms. P. Burwa, Learned Counsel, Government Learned Counsel, appearing for the petitioners. Also heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. DJ Das for the respondent number 8, and also heard Mr. Das, Learned Counsel, appearing for the respondents number 2 to 6. First up, prayer accepted. Registry to list this matter again on. Can it be, because you will also have to go through the affidavits once. We'll have it on 27th. 27 for list the matter on 27 for further hearing. Full stop. The respondents number 2 to 6, in addition to filing the affidavit in question, as prayed for by as contended by Mr. D. Soikia, Learned Advocate General, appearing for the petitioners, are required to bring on record a status report pertaining to the health condition of Joymala. We can use Joymala, after having subjected her to an examination by a team of veterinarians from a veterinary college of the state of Tamil Nadu. Full stop. From a team of professors from the college of veterinary college of the state of Tamil Nadu. Further, it is directed that the respondents number 2 to 6 and their subordinates shall ensure that Joymala is provided the best of care and attention during the period it is under their custody.
My lord, can you be permitted to be present at the time of inspection?
Instead of veterinary, state veterinary.
State veterinary college. State veterinary college.
Highly obliged. Deeply obliged.
Let us get those affidavits, then we will proceed.
Fine. All that I was thinking is, my lord, that's an expert body. I think they are better equipped. Anyway,
Let us not.
Very clear. On the last day, when the matter was listed before another bench, the court was of the view that instead of hearing on the IA, the entire matter will be heard according.
Because we can't hear the interview, may not, I don't know.
Well, that was the direction from the honorable court.
Yes.
But your lordship is not aware of that. It was in a different.
Because there is no order report.
There is no order.
But here, Mr. Majumdar,
My lord.
he had submitted applications before you for being served with the copy of the awards and all.
Copy or?
Award. The awards in
Award.
But you never furnished that copies to him. So naturally, his right to prefer a reference in the matter could not be acted upon. He approaches this court. Now, you have in your affidavit brought on record all those material.
Yes.
Fine. If we take a broader view that being on record, we can always take that into consideration. But would it not be proper? There are two ways now. He has got the award. He can go and take any steps permissible under law, like a reference or something, whatever it is. and we can close this matter, remit him to that direction. Or if the awards according to him are not in tune with the 2013 Act, or it should be brought within the 2013 Acts, there has to be some pleading on record. A challenge to that award will also close. So only by incorporating the prayer can we, because your grievance is, he by incorporating the prayer is changing the nature of the suit. If he makes an amendment to the whole thing, because you have now brought that only in the affidavit, why can't we permit him to file a detailed amendment and then we proceed with the matter?
But I filed my reply and just responding.
Only because that is because of the prayer made by him.
My lord, to kindly see, it's not a case where only one land acquisition case was there. There was no award, and he came to the court, and then we submitted that this is the award. Then he should have an opportunity of reference under section 18 of the old act. Here is a case, my lord. There are cases of 2004. He has approached in 2013. Now, in the amendment petition and also in the affidavits exchange in between, my lord, during the pendency of the writ petition, it is clear that he has got the money. Now, at least the day when he has got the first installment of the award, he was aware that there is an award. He could have immediately said that I am not satisfied with the award and I want a reference under section. Nobody prevented. He waited. He filed this writ petition in one case. There is one case of 2004. He has approached in 2013.
When was the award passed in that case?
2004, my lord.
Huh?
I would have to see, my lord, because 4 or 5 affidavits were filed.
Your lordship.
Anyway, today the IA is before me. Now I'll have to understand whether I should allow this IA or I have to reject it. I find that the prayer, Mr. Kejiwal,
my lord,
the prayer that you have made, even if I allow it, there will be nothing on record in your writ petition in support of this prayers.
Lord,
Because that will be material available in the record, fine, but not in the writ
I have
petition.
pleaded, my lord, in my affidavits. I have stated in my, on the basis of the materials subsequently brought in by them by way of additional affidavit. I also filed my additional affidavits, bringing on record the subsequent development and praying for setting aside the award as well as for.
That cannot be. That has to be in the writ petition per se.
It is why, my lord, in the.
Because here now you are only praying for the amendment of the prayer.
My lord,
Okay, I allow the amendment.
my lord, I have also stated in my that IA
Huh.
that if necessary, I will file a separate interlocutory.
Because that's what is troubling me.
Your lordship may kindly peruse paragraph 6 and
I've
12.
seen it. I've seen
Paragraph
it.
6 and
But that is what is troubling me, because if only the prayer comes in, the writ petition will not be able to handle that prayers.
In that case, your lordship may kindly permit me to file a fresh amendment.
You file a fresh
Yes.
application for amending the whole thing along with this prayer.
Yes.
Then Mr. Majumdar will not have a grievance. He may not have a he may have a grievance on the merit of the matter, but technically he will not have a grievance, because now he has a grievance, because if the prayer is changed, the whole character nature would change, because that is not supported by the writ petition. File it when can you file it? Next week?
At least 15 days.
15 days. Let him file. We'll not close it. We'll keep it.
all right, my lord. I'm just showing one thing. In the amendment petition, page 9, lordship will kindly see, Roman 1, approved ex parte awards dated 18/1/2012, passed in PLA case number 3 of 2006, dated so and so, passed in PLA case number 1 of 2008, then PLA case number 10 of 2004. Now, these awards were in 2013.
And Mr. Kejiwal, these are all independent notices, independent awards, pursuant to one acquisition proceeding. Why have you clubbed it together in a writ petition?
Hello. There is a specific averment at paragraph 9 of my writ petition that all the acquisitions proceedings were undertaken behind my back. Your lordship has seen page
I
number
got
12.
it. I got
I
it.
applied for the copies of the declaration.
No, I got
applied-
it. Each and every acquisition proceeding here may be behind your back, but it emanates under a different notification.
Notification, yes.
So why have these been amalgamated together in a single writ petition? Because these are different causes of action.
Because Milord, the petitioner was.
Only the petitioner is common everywhere.
At the time when the read petition was moved, Milord, the petitioner was not aware about the proceedings initiated and the.
So in
outcome
your
of
writ petition, the different PLAs are not referred to.
Yes, that has been referred.
Then-
There are orders, Milord, by this court.
No, I got it. I got it. I'm just trying to understand. You also knew at that point of time that these are different proceedings.
Yes, Milord.
But what was the thought process behind amalgamating those in a single writ petition? Is it permissible? Because every acquisition proceeding, notice, whatever it is, it would have different connotations. It would have different issues. Some award may be passed at that point of time only. In some, your jirat may not have been given,
Yes.
whereas the land would have been compensated for. In some, it may be after 1/1/2014, as I have noticed. So each and every award has its own. So why were this amalgamated together?
Even, Milord, I can place a judgment of this court in respect of the same petitioner, Milord, where 39 areas of the lands were taken over.
By different,
No, by different procedures.
okay, as straightforward.
Just 1 minute, our only apprehension is. Petition, if it. Petitioner is seeking a adjudication in the form of section 18 of the old Act of Land Acquisition for reference and enhancement, this court cannot do it.
We'll have to
Court
go.
cannot enter into the question of enhancement.
Enhancement. That enhancement will
This
have
is
to go.
what
What I find is Mr. Kejriwal's endeavor may be
My lord.
to show that these things have not been finalized before 1/1/2014. Matters stood finalized after 1/1/2014. So a reassessment under the 2013 Act may be called for.
This is one issue, Milord. And Milord, your lordship is aware in 2012 Supreme Court has held that land acquisition proceeding can be assailed at any stage even after passing of the award.
No,
Here, your
but
lordship may kindly see, none of the statutory mandatory requirements of section 4, section 5A, section 6, section 9, section 11 were followed. I was not, your lordship will find from the notification issued under section 4. All the notifications were.
why were the lands acquired?
Milord,
Why were the lands acquired from you?
for the purpose of drilling operation by ONGC.
Oh,
ONGC
so the
is
land
not a
has been
party.
taken away from you?
Yes, only.
So under 23, one part land was taken away from you at that point of time only?
Yes, Milord, yes.
Some compensation was also
Yes,
paid.
Milord.
So whether the provisions of section 24 will have any application here?
Yes, Milord, that will be applied.
Possession taken.
Taken some land
Amount
money,
paid.
so that
24 is covered.
2 is
Milord.
covered.
Milord, if I can show that the awards are nullity, then the awards will be set aside.
Then you have to go in appeal.
If awards are set aside, then everything has to be done afresh by applying the provisions contained under section 24(1)(a). Because I will show, Milord, from their own documents. From their own documents, Milord, there is a requirement under section 4 that it should be published in the Gazette as well as 2 newspapers, and that the
Okay, but that is on merits. Okay, forget
On
it.
merit.
So what do we do with this?
For the timing, your lordship may kindly permit me to.
I'll adjourn the
Any
matter
application.
on your prayer. You file I'm not permitting you to file a detailed affidavit.
Yes.
You file it subject to the objections which Mr. Muzumdar. Mr. S.K. Kejriwal, Learned Counsel for the petitioner, submits that the matter be adjourned for 2 weeks to enable him to receive further instructions from the client in the matter as regards the further instructions in the matter from his clients in view of the materials brought on record by the respondents in the connected writ petition, which materials were not made available to the petitioner before filing of the writ petition, in spite of applying for the same before the authorities. Also, the above prayer is not objected to by prayer for adjournment is not objected to by Mr. D. Muzumdar, Learned Additional Senior Government Advocate, Assam. Accordingly, as agreed to by the parties, registry to list this matter again
27th, my lord.
27/8/2024.
Obliged.
You can keep this back next time whenever it's right.
Subsequent affidavits will disclose that lapses were there on their part, not for not taking appropriate.
The
steps
earliest
with
land acquisition matter done by me, earliest,
My lord.
first, was with him.
Against him, my lord.
No, with him. He engaged me in one, he put me in one matter, then he gave me all the backgrounds.
My lord. Oh,
Yes,
Supplementary cost list, admission item 27.
yes, Mr. Das.
Your Lordship, the counsel for the GMC is in the middle of an argument. Can it be taken up little bit later? Because paramount in this case.
Your property is not yet demolished.
Not yet demolished.
It's a ground floor
Not ground floor. It's a shop.
shop in
And they
the,
they have extended the into the common areas.
That is the wrong word, case projected by the respondent. Lordship, you
And
can-
the
you say that this is permissible or within the compoundable limits.
Yes,
If it is compoundable, it's for the
yes,
GMC to take it up.
yes.
And you are the residents of that
Yes,
building.
yes.
But you have a different ingress and egress other than
Yes,
the
yes.
ingress and egress to this property.
No.
How did you come there? You are the
I
builder.
have purchased, Lordship. I have
You
from
purchased
the-
that plot,
purchased
that
from the-
area,
That three shops.
and
We
then
are
you
the
extend it.
Yes, Lordship.
That extended.
Who
part
is appearing for Mr. Bora is appearing. Last time you were not there. This time Mr. Bora is not there. It would be better that on the next day, both of you are not there. So we need not go into the issue.
What about?
Lordship, I was unwell on the.
I know, just when?
We have to
Thursday,
go-
Thursday, we have fixed up 2 heavy matters. No,
next week,
Or next.
Tuesday or Thursday.
you can have it on 22nd. 22nd on Metafix corner night, yalla. Nice, 2021 only goes again. That are 27 of course. 22nd, as agreed to by the Learned Council for the parties, raised to list this matter again on 22/8/2024 for admissions. Full stop. Interim order passed earlier to continue till the next date of listing.
I'm okay.
Your Honor,
Mm.
kindly the matter may be taken up at 2 p.m. if-
Today won't be possible because we have fixed up some matters. Some other day.
Okay. Kindly may fix that another date.
This is what, okay, this is that, oh, yes, yes. Yes, what happened? You have done your work. You can sit.
No,
You can sit.
my lord, we have done
We
our,
don't worry. You can just take your seat.
my lord, we have done our work. They have not done their work.
What?
Last time, after hearing the ask, my lord,
Hmm.
this one put certain queries to the other side.
What queries?
My lord, ultimately the question came as to whether we maintain 3 sets of
I'm not on that. I'm not on that. You are the state. You are to see that the criminal prosecution is taken to its logical conclusion. Now, there is a barrier preventing the trial court from proceeding further. You have submitted your charge sheet. From where did you make that charge sheet?
No, at that time it was there.
Where? That is what I want to know. Where was it? Because along with the charge sheet, there is no record that the CD was also submitted. Normally, under a criminal procedure code, that is not required, but it is submitted and then it is returned back by the court.
My lord, in this case, the available from the court, from the CGM.
It was missing from the CGM. No.
Yes.
I don't find that.
That is the understanding of both the parties till now. That was the understanding.
Because we have a report of the vigilance here,
My lord.
and therein okay. Okay, sorry. It was there. So that main copy went missing from the court itself.
That is
What to do now? Mr. Sharma is here. Huh?
D. Goswami, yes, my senior Mr. D. Goswami.
D. Goswami.
And my lord, there is one order whereby this court wanted the assistance of
Mr. Bora. But I don't find him appearing after that.
my
His name is shown.
name is otherwise shown.
Can you request him? Can you also just request him? If he's having some problem, we'll have somebody else. But you are there. You can guide. We'll have it at 2 or 2 today.
Let's see some other day. Today,
2 p.m. Sir said that 2 p.m.
all right, all right.
2 p.m. 2 p.m. Prohibition, Benami property transaction. Yes.
My senior is on leg, my lord. In course of 17, my lord.
Your senior who?
Mr. J. Roy, my lord.
Impugned order is at page 60.
Okay, we'll hear him before passing orders.
The order passed by the Board of Revenue. It was an appeal under section 67.
Is this the case wherein the matter went travel to the revenue board?
Yes, sir.
I don't find the revenue board's order. It seems to be a very forced conclusion reached. Why?
But
The Khatian has been questioned. Everything has been questioned here. But what is the basis for that?
no basis for that.
No. Yes. Okay, Mr. Roy. Let Mr. Roy come.
After some time.
'21 to 23.
These are all covered by Supreme Court judgment, my lord.
Yes,
Because this amendment, it cannot be applied retrospectively.
retrospectively. 88. Have the decision.
I've got the relevant pages, the whole, it's a very big judgment. No, the judgment starts at
Here,
315.
if the property is shown to have been purchased for the family, daughter, wife,
In fact,
then
the then provision permitted that.
permitted that.
Yes, please have that first. No.
So this proceedings have not
Provision in fact permitted that.
permitted that. And they became
Yes, please see.
more
three-
better.
three, Section 3.
3.
No person shall enter into any Benami transaction. Nothing in this subsection shall apply to purchase of property by any person in the name of his wife or unmarried daughter, and it shall be presumed, unless contrary is proved, that said property had been purchased for benefit of wife, it should be or of the unmarried daughter. In fact, the then provision permitted.
Mr. Chaudhary, one factor.
Yes.
If the purchase of the property is if it reveals that it is disproportionate to, then that will not be covered under this. That will have to have a different provision.
Regarding my
The nature.
Benami, from the point of view of section, yes. Now, if your lordship will kindly come to the act. First, Lordships will kindly come to section 3. The
Hmm.
section itself makes the position clear.
Hmm.
Section 3.
No
Lordships will
person shall.
kindly see the chapter, there is a 1.
Hmm.
It came into effect in November 2016.
Hmm.
No person shall enter into Benami transaction, and Lordship may skip 2, 3.
Whoever enters
Whoever
into-
enters into any Benami transaction on and after the date of commencement of the Benami Transaction Prohibition Amendment Act 16 shall, notwithstanding anything contained in the subsection, to be punishable in accordance with so and so. So this amendment came into force, my lord, with effect from 1/11/16.
Hmm.
And the alleged, my lord,
Transaction.
that will
Hmm.
is of 1/2/2011. And the lands were purchased in, my lord, 2014. And the
So-
so-called notice itself is clear on that.
Prior to the amendments.
Yes. Now please come to the judgment, my lord, that paragraph.
Paragraph.
127.5.
What is the citation?
A citation is, my lord, 2023, 3 SCC 315.
এটা বাবা পড়ি ভালো লাগে তো। Para?
127.5, the conclusion. 127 is the whole conclusion. I'll have your attention to 127.5.
Yes.
The authorities concerned cannot initiate or continue criminal prosecution or confiscation proceeding for transaction entered into prior to coming into force of 2016, that is 25/10/16. As a consequence of above declaration, all such prosecution or confiscation proceeding shall stand quashed. My lord, before confiscation, first attachment is done. So in the event in the criminal
Before that, a
proceeding-
notice.
So that is what we have challenged, the initial stage.
So your case did not proceed to the stage of confiscation.
Yes.
And what is the stand of the respondents?
Their stand is that it is applicable. Of course, this affidavit was filed at the judgment.
Affidavit was filed in 21.
21.
Before this decision.
Judgment came in 2023.
Yes, Mr.
22.
What is your stand?
So because the affidavit was filed prior to, thereafter, after this.
No, you just tell me that what contentions Mr. Chaudhary has raised, that this notice of yours cannot be sustained now. Fine, that's the end of the matter. Why should we unnecessarily prolong?
Only,
Huh?
clause F of the conclusion part of Supreme Court.
Hmm.
Judgment.
Clause?
F.
What is it? How does it start?
As this court is not concerned.
As this court is not concerned with the constitutionality of the independent forfeiture proceedings contemplated under it.
On other ground.
On
The
the
opposite
other
question.
ground, the aforesaid question are left open to
So
the.
show me that your case is, this case is covered under
Other grounds.
other grounds. I'll come in. Your only thing is that the allegation subject to correction was that the property was Benami.
Yes.
So now that and that is again under the amendment.
Hmm.
After the amendment, you have come in. So he has shown that these are properties right from 2014, 11 onwards.
11.
2011.
In fact, my lord, we did not go to anything else. The so-called notice itself is clear.
Page 30.
It starts at, my lord, page number 22, the first one.
185.
I'm holding the file in 2183, my lord. There are 3 cases.
2183.
Yes.
Molika.
Only. If your lordship will kindly come to page 22. The so-called notice starts. Then my lord will kindly come to page number. In fact, at page 22 itself, in course of investigation, it has come to the notice of the undersigned that the three flats, namely flat number so and so, so and so, so and so, so and so, are held by the family members of Somoa in the name of Deepika Somoa, Vishaka Somoa, and Mallika Somoa, as per the copies of the agreements available on record. And see the date, my lord, 2/11/2011. One
Part
is
6A,
2/11, two are 2/11/11, 2/11.
all are 2/11 and one is 19/12. So, it's also evident from the details of this one. See. Dr. Chomo, an affidavit filed before the Election Commission, will dated was notarized. Fatima Choma, mother-in-law, grandmother, and good so and so.
And if your lordship will kindly come to page 26, my lord, there are certain further allegations. The last para at page 26. Further, MS Vishakha Somoa owns 6 plots of land, etc., etc., etc. The details of which are given overleaf. And you see all date of purchase is 28/4/14, last column.
Prior to
All
2016.
6. All 6.
Dr. Dulot Somoha is no longer in this one.
So this is the super.
And at page 29, last para, MS Mallika Somoa being considered as the Benamidar and Dulot Somoa being the beneficial owner in the meaning of so and so of the act, since he is the major earning member of the family.
But your case is, this was done for the benefit of the.
And in fact, the
Any
bail
case
law-
against me, doctor, was any case lodged against Dulot Somoa for disproportionate income? Mr. Disproportionate income, any case was registered?
that time.
Okay,
Perhaps, my lord, now he is no longer a public servant. Now it will be difficult also.
maybe. No, this is after this period as a public servant, this allegation. After 11, he was no longer a public servant. So anything more?
The judgment is there, lordship,
Can I record that and quash it?
because lordship,
Can I do it?
I cannot submit against the judgment of the Supreme Court.
Mr. Chaudhary, I'm not disposing it off today, but disposed of, that would be the order. I'll pass it either on Monday or Tuesday, I'll pass the orders. Because I'm having a slight problem with.
No, it's okay. End of the day, one has to figure out how to.
No, they have enough work, so let them do that and then I'll give this.
Three meters.
3 matters come. Heard the hearing, heard Mr. K. N. Chaudhary, learned counsel for the petitioner, assisted by Mr. R.J. Das, learned counsel, appearing for the petitioner. Also heard Mr. S.C. Kel, standing. Your standing counsel or?
Yes, senior standing counsel, income tax.
Income tax. Senior standing counsel, income tax department, appearing for the respondents. The hearing has been concluded. Registry to list this matters again on 16/8/2024 for delivery of orders. I'll have it before that only and I'll give it out.
My lord, sorry to interrupt, lordship. Item number is 27, your lordship was pleased to fix the matter on 22nd, lordship. On 22nd, I have some difficulty.
When you want it?
Can it be on 3rd of September, lordship? I'll inform the other side, lordship.
Oh, 3/9. Kindly inform them. Yes, Mr. Roy. How are you now?
I'm okay, my lord, but.
But you don't look be back, you're not back to the original self.
No. That will
We
take,
want you to be back there.
that will take some time, my lord.
It has come
But
so
I'm
far.
trying hard, my lord.
Yeah, it has come so far, so that will not take much more time. Yes,
The order I was reading at page 60 is the imping order.
Mr. Roy,
My lord.
the order of the revenue board somehow does not inspire.
My lord, this is with regard to draft Khatian and Paka Khatian, my lord. There is a judgment of this court, my lord, that draft Khatian is, one cannot derive the right, my lord,
From a draft Khatian.
from a draft Khatian. It has to be Paka Khatian under.
And you
Rule
mean to
35.
say that there was no Pakka Khatian made here?
No.
But what about his occupancy thing, question?
No, that occupancy is, he was not established, could not establish also the occupancy tenant, my lord. Because it is less than 2 years, my lord, 2 years. It occupancy
Three.
tenants is that 3 years. It has
3
to-
years.
But he is 2 years, my lord.
Where do I get that?
Yes.
But there is a report, the lordship will find at page.
Is this fact a factor, Mr.
Yes.
Then?
Page 23.
Then?
This is not the fact considered by the court, my lord. The report.
Forget it. We'll not go into that. But if you are not within the
No.
uh,
Here.
terms of the Act of Occupancy Act, Tenancy Occupancy
Yes,
Act, then how can your right?
We are, my lord. We had been there, my father. Since
Okay, show me from when you were
Not
paying
page-
land revenue.
Page 23.
Show me from when you were paying land
They have
revenue.
not produced any document of land revenue, my lord.
When were you paying land
My
revenue?
lord, where the Khatiandars,
From when were you the Khatian, right?
the Khatian, your lordship will find it's annexed and the.
That's not a kacha, that's a kacha Khatian.
It's a Kacha Khatian. and
So
the-
when were you in occupation from?
My lord, we have been in occupation since, my lord, the time of my father. It was, my lord, in the year 1972-73.
72, 73. So you being in occupation of that part of land of your landlord, you are required to pay land revenue to that extent?
My lord, no, it was, since it was I was a Khatiandar, I was cultivating in the land and the portion of, my lord, rent I used to pay to the
To the
landlord, to the
landlord.
pattada,
How?
original pattada.
How? Where is that material?
But this material can't be.
Where is your statement to that effect?
From a statement, my lord, because I have a Kacha Khatian. Kacha Khatian is issued, my lord, on the basis of these terms and
I got it.
conditions.
Kacha Khatian is a one-time exercise.
Afterwards, my lord,
After that,
after
that
that-
you were complying with the requirements of the Act.
Yes.
Something has to be given.
Final Khatian was issued in my favor that I have submitted before the Board of Revenue.
Where's
Your
the final
lordship will
Khatian?
find the order at page 57. This is the order dated 8/8/2017. Advocate for appellant present, advocate for respondent not present. Cases that the land bought up was under tenancy when it was sold and tenant was the father of the respondent. The appellant has mentioned that as per the draft Khatian, the father was tenant only for 2 years, that too as shown on Kacha Khatian. Let respondent give the status and submit Pakka Khatian and a documented proof. Thereafter on 7/11/2017, both parties present, record received. Respondent has submitted.
Respondent means this is you.
Yes, my lord, because they were the appellant, they are in the board of.
So where is that Pakka Khatian?
Well, it was there in the record because in the order also it is reflecting.
This may be only, we can't give much importance to this. Revenue board orders, we can't give.
But so far as revenue. board
Sometimes
is-
we also, this is not a order. If it was a civil court order, it would have been a different connotation. But these orders, sorry, at least this court will know. Because it might have just written. It might not be the proper. So where is your
But so far as the
Pakka Khatian?
finding of the Board of Revenue is concerned, if I may take your lordship to page 61. The last paragraph. It was the argument on the side of the appellant.
At that are produced by is only a draft, not a, and which did not bestow rights and so and so. Further, the class of the disputed land is also changed into residential class. And this is where is this land located?
My lord, in Jorhat.
Jorhat. So it has come into a town area. Now, once it comes into a town area, how that will continue?
But there is a procedure of ejectment, my lord, as prescribed under the act, and no notice was given.
You are
by
not
the class.
you are not covered by the Tenancy Act thereafter. Once it comes into the town
I
area,
still, my lord, because my lord, once the Khatian was issued, I still have the.
you have a draft Khatian. Where is your Pakka Khatian?
Pakka Khatian, my lord, as per the order, it was submitted before the Board of Revenue. It is not with us. So,
Right?
this is the position, my lord.
You only submit a, no, come on,
We have
Mr.
submitted-
Counsel.
we have
That we
submitted-
are not going to accept. I'm sorry. That we will not accept. That is not no plea.
But I inquired with the client also. Well, they, as per them, well, they have submitted before the Board of Revenue. The
I'm
Pakka
sorry.
Khatian.
That
But so
this
far as-
court will take with a pinch of salt.
Well, so far as possession is concerned, occupancy is concerned, we have been in possession.
We have the records of the.
Yes,
Have we gone through these records?
I have gone through.
It's not there.
It's
Then,
not there.
then, and where is the finding of the court that this on production was kept in record?
The finding is not there. If I may read the 57, page 57. order.
Copy to be furnished to the appellant along with application.
Respondent.
Were
has
you
submitted-
given a copy of this, Mr. Roy? Were you
Hello?
given a copy of this?
They have submitted same Kacha Khatian as a Pakka Khatian before the court.
That is a mistake.
They have not submitted.
Because
Pakka
here
Khatian.
in the final order, that is not there.
No, it's not there. He could not submit, my lord. He had submitted again the Kacha Khatian to be treated as Pakka Khatian.
The page 59 is the Khatian it is available in the record, form number 19.
That is a pakka.
No.
This is
That has been
Kacha
issued
Khatian.
under Rule 31, my lord. Pakka Khatian will be under 35, Rule 35.
35.
It is rule 31.
What rights flow from a pakka? Pakka to his,
Pakka is.
is a writing.
Khatian, my lord.
Okay, then, but what is the status of a pakka, kacha one? It's just
No, my lord. Eh,
because he has not reached that, achieved that 3 years. That is why a kacha khatian is used. Issued.
Kacha Khatian, he cannot derive his right, my lord.
No. Why is it issued then? What is the purpose of a kacha khatian?
Because there is a procedure, my lord, to issue Pakka Khatian. I will place the judgment because in this case I have lost it, my lord. Mr. Justice Amitabh Roy has delivered the judgment.
So,
Para 17, 18 and 19, my lord.
what is the citation? 2007 to GLT 619. Para 16 and 7.
Para 15, lordship may see. Para 15, my lord. The Tenancy Act in terms of section 2 thereof does not apply inter alia to the land owned by the union or state government or local authority which the statute classifies tenants contemplated thereunder into two categories, namely occupancy tenant and non-occupancy tenant. A person who for a period of not less than 3 years has continuously held the land as a tenant would have been right of occupancy in that. So he stayed for 2 years, my lord. And now para 17, my lord. Chapter 7 of the tenancy rules, with the procedure for preparation of record of rights, Rule 29A envisages the various stages of process. Under section 30, the mode of preliminary survey and record of writing is provided. Thereunder, after the boundaries of all the holdings of the tenant are surveyed and demarcated, a draft chitta some settlement officer. The chitta would be.
Okay, sorry, got it. Yes.
That is.
But it is as per Rule 31 of the Assam Temporary Settled Areas Tenancy Rule 1971.
But
That's
here,
how
the decision of this court
Kacha
says no right flows to
No right.
from that kacha khatian. If that be so, and you are the landowner,
Yes, my lord.
so
that one aspect is there, my lord. This Pakka Khatian, my lord, though my client is saying that it was submitted before the board of it is not in the record.
sorry, we can't take that. You go before the civil court, assert your right. We permit you to withdraw this. We'll even observe that the conclusions by the Assam Board of Revenue will be of no consequence. And the Assam Board of Revenue literally has asked you. So go before, withdraw this. We'll not go into it. Otherwise, if I have to come to a conclusion that you don't have a right, I'll have to record now from this judgment. That'll prejudice your interest before the civil court.
Right, I may take last.
At 2 o'clock, you have your instructions at 2 o'clock. Mr. Roy, you need not be here.
My lord, I have
can
one
be-
matter at video conference.
You go ahead.
Can it be
I'll-
on 13th, my lord, 13th, next week?
Why take it? You have a call with your client, talk, come back, we will do it. And I'll even permit you to go in terms of that order or even the liberty granted by the revenue board. And I'll even observe that the observations and conclusions of the revenue board will not come in the way. There would be an independent finding altogether. Fine. We'll give you only a time frame. Within a time frame, you have to.
My ownership right has been cancelled by the Board of Revenue. It was granted.
That
by
is
the-
it. Now that would be subject to, I'll say that is subject to your right determined by the, because here you will have to show that you had acquired that
Yes.
occupancy right. Because here we are stuck at 2 years. You have not completed that 3rd year. So
So since 1972, 73. we have
that
been
is all
employed.
disputed. Kacha, nothing happens. So kindly assert your right. You think over it. If you want to argue this matter, come back and tell me that I'll argue this matter. No problem. We'll have it on a different date.
13th,
But-
my lord, then.
But if I have to decide, I'll have to go into that and say all this. That may cause prejudice to you. So we'll say any conclusion of the revenue board is subject to your determination by the civil court. Come back at 2 and tell me.
13th, it will be convenient.
Okay. As prayed for by the learned counsel for the parties, list this matter again on 13/8/2024, on which date the learned counsel for the petitioner shall reply, shall demonstrate his rights, claim, the rights, occupancy rights claimed by him basing on a kacha khatiyan
Parted, my lord.
for further hearing. 13 I'll be.
Obliged.
Obliged.
It- Nice seeing you sometimes, Pragyan.
My lord.
Although I know you are very busy.
No.
Thank you. Yes.
Lordship, in this matter, this conducting counsel, Mr. Rashtriya, is not sleeping well today, so I would like to seek a short adjournment.
Prayer has been made for an adjournment in the matter on behalf of Mr. S.P. Roy on the ground that he is indisposed. The same is not objected to by Ms. U. Sharma, learned government advocate appearing for the respondents. Also, accordingly, registry to list this matters again on 28/8/2024.
Are you obliged? Obliged.
Net please, Your Lordship. Account of the cases that, my lord. Respondent number 2 was appointed as superintendent, postal superintendent on 30/8/2013. Subsequently, on the basis of complaint lodged by student and warden, my lord, he was suspended on 17/2/2016. And later he was terminated from service. Thereafter, my lord, matter was referred for conciliation. That was failed. And then, my lord, referred to labor court for adjudication, whether his termination is justified or not, and whether he is entitled to reinstatement with backwards. And the labor court, my lord, passed award in favor of the workman, my lord, that is respondent number 2. Height award dated 18/9/2017 in reference case number 3/2017. And thereafter, the petitioner approached the honorable court by filing a petition.
You approached.
My lord.
That was dismissed.
That was dismissed, my lord. Initially, that was award was paid and subsequently dismissed, my lord. And during pendency of the repetition, my lord, the respondent number 2 filed another IA under 17B, section 17B of Industrial Dispute Act for, my lord, current salary, and that has been allowed, and that has.
There was a stay order in the. Now that award has been interfered with, the award has not been interfered with by
No.
this court. So if that be the position,
And thereafter, my lord,
what is the grievance here then?
here, my lord, impugned order is annexure 13, my lord.
Huh? Annexure?
Case 100, my lord, annexure 13. He was, my lord, reinstated by a order, my lord, by the petitioner, but he did not join. With the plea that order was silent regarding backwages. Thereafter, another order has been passed, my lord, that process for, my lord, allowing the backwages is under process, and he will be paid immediately after his joining. And he was ordered to, directed to join in service, but this time also he did not join. And he shifted from earlier address, he did not provide. Till that, my lord, has not provided his present address, my lord, to the office, my lord. And thereafter, he filed one application before the labor court, my lord, that is under section 33C2, my lord, disputing the, my lord, quantum of back wages, the salary. Actually, there was no dispute till that, my lord, but he has filed, and in that case, we have filed objection. And he adduced evidence, he was cross-examined, and management also adduced evidence, my lord. When, my lord, time of cross-examination was came, my lord, then one Bohanta Kumar Kolita, my lord,
The
representing
representative.
the workman, my lord, he wanted to cross-examine the, my lord, management witnesses. And then objection has been raised, my lord, because he was not eligible for, my lord, representing the workman under section 36, my lord, of Industrial Dispute Act, my lord. There is provision who can represent, my lord, the workman and the, my lord, the manager.
Number 99.
And after hearing, the objection has been dismissed, my lord, allowing Bhanta Kumar Kolita to, my lord, represent the workman on the ground that in earlier proceedings, Bhanta Kumar Kolita, my lord, represented the workman without any objection. And it is a continuous process. So objection was, my lord, not objection was not sustained.
Where is the award?
My lord,
The final page 23. No, final. There were two issues framed. There were two issues framed in the by the labor court.
my lord,
Where is the findings with regard to the second issue? That is the issue now before us.
no, my lord. That is not issue.
No. Back wages, fixation. What was the back wages granted by the
Back was just granted.
where? Okay, full back wages.
Full back was. We have not disputed.
Now you say about Mr. Kolita coming in,
My lord,
but Mr. Kolita also is there in the original.
earlier process.
Then?
Now, my lord.
Now,
during this
just
proceeding, my lord,
getting the things out. Now, there was a specific issue
my lord,
with regard to full back wages.
my lord.
So full back wages means full back wages. So if there was a dispute with regard to the wages you had given to Mr.
No,
Deep,
matter. No matter. What happened? We have not submitted any amount that this is your back wages. Neither he approached that I am entitled to this much of back wages. No dispute was there, but he dispute directly raised before the labor court. But under section 33C2, my lord, there must be some dispute regarding the back wages, my lord. Then regarding my lord salary, then only he can approach under this act, my lord. And that is considered condition precedent, my lord. In my lord, Industrial Dispute Act, section 33C2 says, my lord, where any workman is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money, and
if any question arises as to the amount of money due or as to the amount at which such benefits should be computed, then the question may, subject to any rules that may be under this act, be decided by such labor code, as may be specified in this behalf by the appropriate government within a period not exceeding 3 months. Here, my lord, there must be some dispute, my lord. We have reinstated, he has not joined. Thereafter, another order has been passed. He has not joined. He has shifted from earlier address. His present address has not been, my lord, communicated. And even, my lord, during this proceeding, this court allowed us to pay him the salary till the date of his reinstatement, as we agreed to pay. That has also been deposited by way of draft before the registry. That also has not been received by the workman till today. That is like almost 1 year. Now, my lord, this is not the issue.
Where is the order of this court?
My lord. 17/5/2023, my lord. And we have deposited before registry on 31st May 2023. Till the date of reinstatement, we have paid our agreed amount, agreed salary.
So this 1,88,600 is the amount due to him from the date of his dismissal till the date.
Yes, my lord, till reinstatement. Because in the midway, my lord, he has already been paid some amount during the proceeding of 17B, my lord, as per order of this honorable. And after deduction of that, this amount was outstanding.
Yes, Mr.
Award was passed in my favor. That award they assailed. The writ petition dismissed. Now we approach before the labor court for the computation of the amount due to us under section 33C2.
No, why was this amount not? What is your claim with regard
My
to this?
claim is back wages in terms of the award.
No.
So that
There has to be a back wages that can be computed. What is your computation that this is the amount I have to receive?
No, yes.
Where is it? You can tell me today that I will have to receive, this is my monthly salary into so and so. This is the amount due to me. Where is that quantification of that amount from your side?
I filed an application under section 33C2, Miller.
Because even in that application, you will have to, in terms of the provisions of 32C2, quantify the amount.
Yes, labor code has to quantify this thing.
No. Okay, you have quantified.
Labor code has to quantify. Labor 33C2 is an executing code. They have to quantify it. Now, they have no objection. So, for this application, only objection is that Mr. B.K. Kolita should not appear on my behalf. That is the only objection.
What is that 36 or something?
33C2.
No, there is a bar
Yes,
of a union activist from appearing.
Before going 36, you should just have a glance to 33C. Recovery of money due from an employer. Where any money is due to a workman from any employer under a settlement or award, or under the provisions of chapter 5A, 5B, the workman himself or any other person authorized by him. Here 36 is not specifically any other person authorized by him. I have authorized Mr. B.K. Kolita to conduct my case. And when he went to cross-examine the witness, they raised an objection under section 33C2 or 33(6) or something like whatever may be similar.
So this 33 by any other person authorized to him must be a person who is recognized under the provisions of this act.
He must be an union official.
No, there is a difference here. If subject to correction.
No problem.
A workman who is a party to a dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or other office bearer of a registered trade union of which he is a member. Is Mr. B.K. Kolita
Is a member
of
it.
your, that same?
Yes.
No, my lord, your lordship.
That is their
Kindly
study.
for a moment, kindly see the page 103, Annex 14, by which he was authorized. Only he was authorized as a trade union activist.
Alexa, column. Page.
Page 103.
103.
14, my lord.
Only this word is the whether PK Kolita.
10.
PK Kolita can appear.
103, Annex 14. ma'am.
Whether BK Kolita can appear on behalf of the workmen.
That is the issue.
That is the only
That is
question. But BK Kolita has appeared in the main defense. Award was passed. No objection was raised. Then they preferred a High Court writ application. Writ dismissed. 103.
103.
103.
So why was this objection not raised when he was representing the respondent in the labor court, in
My
the
lord,
reference?
there may be, my lord, mistake on the part of earlier set of counsel, my lord, but there should not be, my lord, estoppel against the provisions of law, my lord.
Okay, fine. Tell me, under which provision of 136 he is not eligible?
My lord, first one, a workman who is a party to dispute to be entitled to be represented in any proceeding under this act by any member of the executive or other office bearer of a registered trade union of which he is a member.
Okay.
Workman is not a member of any trade union. That is admitted.
Then you come to C.
My lord.
Hmm.
Second, my lord, I am going to clearly, my lord. B, any member of the executive or other office bearer of a federation of trade unions to which the trade union referred to in clause A is affiliated. Means he
Okay.
is not a member, my lord, trade union, so it is not.
C.
C, where the worker is not a member of any trade union by any member of the executive or other office bearer of any trade union connected it, or by any other workman employed in the industry in which the worker is employed and authorized in such.
So show
manner.
me how BK Kolita is excluded from the provisions of section 33C2, 36C.
If assuming that BK Kolita is a member or executive of any trade union or federation, my lord, then also that trade union or federation should be connected with.
Show me
the
that it is
industry.
not connected.
My lord,
Show me that it is not connected.
not connected, my lord, because admitted fact in the affidavit in opposition also admitted that there is no trade union, my lord.
It does not say industry means your industry or industry as a general.
No, my lord, that particular industry, the industry, my lord. Employed to
In the
industry.
employed.
That
So where is
particular
that
industry.
statement? Where is that statement that he is not involved?
My lord,
Where is your contention that he is not covered by 36C?
my lord. I have categorically stated, my lord.
Mr. Dasgupta, we'll just hear him. You take your seat. Hear him.
My lord, paragraph 15.
1-5.
Nine. Case 14. my lord. And my, sorry, my lord, paragraph 13, page 11. Here, my lord, we have stated that the respondent number 2 adduced evidence by examining himself and he was cross-examined by the petitioner. Thereafter, the Secretary of Peace also filed his evidence in affidavit on 10/6/22 in support of the petitioner's case, and the case was fixed for cross-examination on 30/8/2022. When one Sri Vasanta Kumar wanted to cross-examine the management witness by representing the respondent number 2, The counsel for the petitioner brought to the notice of the learned labor court, Assam, at Guwahati, that Sri Bohanta Kumar Kolita is not entitled to represent the respondent number 2 in view of the provisions of section 36 of the Industrial Disputes Act, as Sri Bohanta Kumar Kolita is neither an executive member or other office bearer of trade union of which the respondent is a member, nor he is a member of any trade union connected with the employment of the workman. So it is specifically stated. And my lord, in counter affidavit, they have admitted that no trade union is operating in the.
Where?
industry, my lord. 110 page, my lord. In the present case, the petitioners are service providers having more than 10 employees. They do not have their own trade union at their establishment. And admittedly, the respondent cannot be a member of a trade union connected with the petitioner in the absence of one. Under 36C, my lord, he may be eligible if that trade union of which he is a office bearer is connected with the industry. But there is no material before this honorable court that the member of which trade union is anyway connected with the particular industry of the petitioner.
Okay, what is the final conclusion?
My lord.
Decision of the, on your objection by the trial court, by the labor court?
100 page, 101.
We have already stated before the, my lord, labor court that we have no objection if the management witness is cross-examined by any person eligible under the section 36.
That is your submission,
Madam.
Mr. Haloi's submission.
That is our submission.
Hmm.
We have no objection. But our contention was that B. Kolita was not eligible under section 36.
First word, paragraph, my lord. 101. Labor course finding. To enforce the award dated 18/9/2017. Now, your lordship can.
No, he is a trade unionist, he's a union activist. He's a activist in this line. I'll use the word activist. He's a member of several trade unions, including INTC.
That was not the.
Now, the petitioner has confidence on that man. He participated in the execution, I mean the award, in the reference. So reference, then 33 continuous proceedings. What prejudice is being caused to you?
My lord, if anyone can represent.
No,
on the
anyone,
basis
no,
of confidence-
he's at least a trade unionist.
No, my lord, the trade union activist
I
is
got
nowhere
it, but
defined.
what is the prejudice cost?
My lord, prejudice cost we have stated in this. my
He is
lord,
very strong.
proceeding, my lord.
He is
It's
very
not-
strong.
Actually, what happened? There was actually one settlement process was, my lord, already. my
You
lord,
forget that I'm only concentrating on this. What is the procedure? What is the prejudice cost to you here?
My lord, since he is not, my lord, authorized person, he is by the law, my lord.
Then that is a ground you should have taken in the award while challenging the award. You have not taken that ground. Vike Kolta was very much there.
My lord.
And here, what is the, he is not a, there are two categories of people.
My-
Trade union members, officers, and a member, a worker of your organization. He can also come in. Now, the only difference is that trade unions must be connected to the industry. He is not directly connected, but there is a statement that he is also involved. You are in a service sector. He is also involved in the service industry.
No, my lord, he is neither a, my lord, workman also.
What is the prejudice cost?
My lord, prejudice
Can
is-
you show me any decision of any court, our court or the
My
Supreme
lord,
Court?
regarding prejudice, there is no decision, but there is decision of another high court, my lord, where it is stated, my lord, it is mandatory.
Show me.
To my lord, my lord.
The trial court has also recorded that. There is nothing on record to hold that the management will be prejudiced if B. Kolita is engaged to represent so and so.
That is, my lord, recorded in the labor court. Paragraph 8, my lord. Yes, sir. But once it is detected that he is not eligible to represent the workman matter under the provisions of law, we cannot be allowed further matter.
Again, the fact whether connection, that is what has been directed to be done.
That is also not discussed by the.
It's not here. Any other decision
No, my lord.
of our High Court? No. Yes, Mr. Raskin.
Now, my lord, if your lordship pass any order in his favor, then I can engage lawyer, no problem. That is
No,
for
it's
the-
not that. The issue has come up before us. We
Alright.
want to resolve it.
Now, my lord, his contention is that the person concerned.
Because there is a decision of High Court of Orissa, Division Bench Judgment, wherein it has been said that Section 36 is mandatory. If you can show me that it is directory in nature, then maybe we can change our view.
Oh, yes, I got the point. Now, my lord, industrial dispute may be of different kind. It may be adjudicated through a reference. It shall be adjudicated through a reference for substantial dispute under section 10. And so far section 33C2 is concerned, it is an executing court. Court of execution. Now, if your lordship goes through the provision of section 33C clause 1, it will be very much clear. We need not go all these things here.
33.
C clause 1. Basically, we have filed an application for computation of money in terms of the award. Under section 33C2. 30C, you also got it. Where any money is due to a workman from an employer under a settlement or an award, the Labor Court passed an award. That award was assailed before this High Court. High Court has dismissed this petition. Then again, we approach to the Labor Court for money due to us to compute this. Or an award under the provisions of such as chapter 5A, chapter 5B, the workman himself, he can himself, or any other person. That is very important. Or any other person authorized, there is a special provision, him by writing in this behalf, or in case of the death of the workman, that is not very important. So, if it is a case of execution, in terms of an award, I can file an application by myself, or I can authorize any other person. But so far the other disputes are concerned, section 10 dispute or section 10A dispute, it may so happen. I have not gone through that judgment, whether that case is arising out of a section.
Same case.
Section 36,
36C. Same issue. Yes, it will be. Now, Mr. Dasgupta, you are suffering because of this. Your thing is not being taken. Why don't you, we can decide, but why don't you
engage a lawyer?
Lawyer, he'll give consent. You give your consent. He'll give his consent. Because engagement of a lawyer is also permitted under 36.
No,
earlier it was not there, then I think they amended it.
No, they are he is appearing in the Labor Court.
Then you appear through a lawyer. Why this unnecessary controversies? Because that is also delaying the payment due to you.
That can be done, no problem. Number so far this case is concerned, it is not a case under section 33C2.
But Mr. When the act itself provides for, it's not there, notwithstanding anything. There is no notwithstanding anything said in clause section 33C. That is not the words of 36. Words of 36 is same. Authorized by him in writing, a party, workman who is a party to a dispute shall be entitled to be represented in any proceeding under this act.
By any member.
That you leave it. But here the thing is any proceeding.
No, anyway.
And
by
here
any member of the executive or other office bearer of a registered trade union or which he is a member. Any member of the executive or other office bearer or federation of a trade union to which the trade union is referred to clause A is affiliated.
Now,
where the workman is not a member of a trade union, by any member of the executive or the office bearer or any trade union connected with or by any other workman employed in an industry in which the workman is employed and authorized to such member as may be prescribed.
So this prescription with regard to who can represent.
That's the question of prescription. Or I can But maybe I can engage a lawyer.
That's it.
That is better. Without making any final, without making any observation with these things.
We'll
Ah,
say.
Yes, that can be done. No problem. I will go there.
Because you are losing. And what about this money that you are depositing? You take it, we will observe that the amount that has been deposited will be withdrawn by you, taken by you.
No, that has not been, that was deposited in the High Court, no?
High Court, huh?
No, that was a draft was deposited and it has been lapsed.
Okay. You revalidate that draft and pay.
My lord, actually, it was fault on their part. We have personally also.
No problem. No, let the matter be completed by.
Mr. Suma, you are
Without
not
going
before
in
the labor court. You are in the High Court.
At first,
So
my
a
lord,
slightly broadened view is to be taken. Man is entitled to some money. This is a part of that.
Yes.
my lord.
So why don't he will not get it?
Of the record, my lord, we requested to join him, my lord, several times.
Forget it.
Either
That
you
is up
join-
to him. That is up
either
to him.
join, or you come into agreement that we are ready to pay, but he did not come.
What is this industry?
My lord.
What is this industry? What do
It
you
is,
do?
My lord, nursing college is running on, my lord.
Oh, you run a nursing. So, Mr. Dasgupta, what about the money?
No, I'm sure it will be computed by the labor court.
That will do.
But that's all right.
So this is left, this is gone.
If he pleases to.
Now it is
revalidate
3
the
months.
draft-
A draft is also having a validity of 3 months.
Yes.
So it is gone. It was in his name. Registry also cannot withdraw it. Okay. The present proceedings are heard, Mr. Mr. Halloway is having a ringside view of the matter. Heard Mr. UK Das, Learned Counsel for the petitioner. Also heard Mr. Dasgupta, A. Dasgupta, Learned Counsel, representing the sole respondent. For the respondent number 2. Ms. So-and-so appears, Ms. Goswami appears for respondent number 1. Uske baad Dasgupta for respondent number 2. The petitioners have assailed an order dated 30/8/2022 passed by the Labour Court, by the Learned Labour Court at Guwahati, wherein the challenge as presented by the petitioners to the sole respondent engaging one B. Kolita to represent him in the proceedings so pending was negated. Full stop. In pursuance to the award passed in favor of the respondent number 2 herein by the Labour Court Assam, wide award dated 18/9/2017 passed by the Labour Court Assam in favor of the petitioner of the respondent number 2 herein, and the same having been upheld by this court, wide an order dated 3/9/2019 in WPC number 6956/2017, the respondent number 2 had instituted a proceeding under the provisions of section 33 C, C bracketed 2 of the Industrial Disputes Act 1947 for computation of the amounts receivable by him in terms of the award passed by the Labour Court, by the Learned Labour Court, Assam, Guwahati. Also, during the pendency of the said proceedings and the management witnesses being examined, the management having found, the petitioners having found that the such examination was being carried out by one B. Kolita as the representative of the workman herein, raised an objection in the matter on the ground that Mr. B. Kolita, Mr. B. Kolita could not have represented the respondent number 2 before the Labour Court, inasmuch as the same would have been a violation of the provisions of Section 36 of the Act of 1947, to be more specific, in violation of Section 36 bracketed 1 bracketed C, so Roman small c, of the said Act of 1947. First, accordingly, the learned Labor Court on considering the said issue, rejected the objection raised by the petitioners hearing, wide an order dated 38/2022, and thereby permitted the respondent number 2 to be continued to be represented before it by said B. Kolita.
This is order dated 1/9/2022. Is 100.
Page
100, madam.
100.
Yes. 01/09/2020. dated.
Oh, sorry, 1922 day order. Upar mein bhi 19 hoga. Sorry, I was reading it along with that. 1922. Okay. Challenge me 1922. Huh? Also, being aggrieved, the petitioners had instituted the present proceedings before this court. So, at the outset, it is to be noted that this court, while issuing notice in the matter, was pleased wide order
Fourteen 9/2020. Notice was received and take the further proceeding.
please wide order dated 14/9/2022 to state the proceedings under section 33 bracketed C bracketed 2 as instituted by the respondent number 2 before the learned Labor Court Assam, Guwahati, Assam, Guwahati. Also, the learned counsel for the petitioner, the learned counsel for the petitioners, counsel for the petitioner and the respondent number 2 have stated at the bar that an agreement has been reached by which the respondent number 2 hearing shall not insist for being continued to be represented by said B. Kulita, and he would engage a learned counsel, a learned advocate for representing him in the proceedings so pending, so instituted by him before the learned court. Also, learned Labor Court Assam. Also, it is to be noted that the provisions of section 36 bracketed 4 mandates that in any proceeding before a labor court, tribunal or national tribunal, a party to a proceeding dispute may be represented by a legal practitioner with the consent of the other parties to the proceeding and with the lead of the labor court, tribunal or national tribunal, as the case may be. The learned counsel for the petitioner, the learned counsel for the petitioner has also submitted that he would have no objection in the respondent number 2 being represented by a learned advocate before it, in as much as the management is also represented in the proceedings by a learned counsel. Also, in view of the said position, the writ petition need not be detained any further, and the same is disposed of by requiring the petitioner hearing to engage a learned
Respondent.
a respondent number 2 to hearing to engage a counsel of his choice to represent, learned advocate of his choice to represent him before the learned labor court in the matter, in case number, it is execution case number. It's case.
Case number 33C2.
Here, case number 02 of 2020.
Case number 2 of oblique 2020 under section 33 2.
C2.
33
C 2
bracketed 2. Right?
Page 98. Well, you will get.
Under section 33 C2. presently pending disposal before the Labour Court of Assam at Guwahati. So, in view of the above agreement between the parties, and the observations made by this court herein above, the present writ petition stands disposed of in terms thereof.
Regarding drafting, my lord,
Full stop. At this stage, the learned counsel, uska disposal ka again. At this stage, the learned counsel for the petitioner has submitted that in terms of the directions passed by this court, wide an order dated
17/5/2023.
17/5/2023. An amount of rupees 1,88,660 600 was deposited by the petitioners in the in a form of a draft drawn in the name of the petitioner herein.
Respondent number 2.
Respondent number 2 herein. So, however, on.
Deposited on 30.
In the form of a draft bearing number 499485 dated 35/2023 for the said amount drawn in the name of the respondent number 2 herein. So it is contended by the learned counsel for the petitioners that the said draft by the parties to the proceeding that the said draft was not encashed by the respondent number 2.
No, I have not drawn the, just deposit the register.
Not encashed, not received by the respondent number 2 and consequently not encashed by him, and accordingly the same has so lapsed. Full stop. The petitioner hearing is that petitioners hearing are at liberty to take back the said draft from the registry of this court on submission of an application along with a copy of this order. That'll do. That is just an ornamental piece now. But
there is something else in this case.
This draft you have made from your CC account, or you have deposited the money and then got this draft made? Deserve. Then you take back and you encash it. You will have to encash it now, not used.
I don't know what is the procedure.
What happens to a draft, Mr. Muzumdar, if it is not encashed? Draft. Huh?
Possibility to lose it is validity.
But if I have made a draft in your favor, after paying the amount.
In favor of the High Court?
No.
Oh, then it is.
Then I have made it. I'll have to give the money to the bank, then take the draft, or it will be how is it made?
No, you have to deposit the money to the
Full.
bank.
That's it.
That's it.
You are entitled to get that money back.
Yes.
Take it back, and for having it and having the amount involved therein reauthorized to itself.
No, that can be your document. You can withdraw this amount from the bank.
Mr. Dasgupta's client seems to be very rich. Yes.
It get
lapsed after 3 months.
3 months.
Huh.
And then thereafter, the one who has made the demand draft, he has to go and go back and deposit the demand draft and get revalidated the cash back.
Get the cash back. Okay. You do it. With
Only
the
one
above
time he
observations
might have
and directions,
done so.
the writ petition stands disposed of. I think you go ahead and fight it out, get your money and finish it. But it seems that you are well off.
That's the ego problem.
And both sides.
Ego problem with DK Kolita.
No, both sides. Both sides have that. Both sides. There, it's there. It may be difference of degrees only. But
Money
ego is too much.
Amount is not very much, 1 lakh or 2 lakhs.
But it's good. But it's good for someone. If somebody has some ego, it benefits somebody else.
That's
Like
ego
it-
problem.
Hmm? But hey, but the Mujumdar Sahab ki bata sakti hai. Yes. What have you decided?
I'll withdraw the case, then go before the concerned.
What's up?
Worship, I only pray that a little facts may be recorded.
Huh? Will not go into it. You want me to record the facts? Okay, I'll do that. खाली नीचे का लिखेगा ऊपर का देना dictation. What's up? Mr. C. Burwa. You are
A. Borwa.
yeah?
A. Borwa.
A. Burwa, learned counsel for the petitioner. After having argued, after having made his submission for some considerable period of time, prays that he be permitted to withdraw the present writ petition with the liberty to approach a civil court of competent jurisdiction for redressal of his grievances. Full stop. Given the nature of dispute raised in the present proceedings, the petitioner is permitted to withdraw the present writ petition with liberty reserved to him to approach a civil court of competent jurisdiction for establishing the loss so occasioning to him on account of the activities carried out in the area wherein his residence is so situated by the respondent number 1, 2, 3, and you are respondent number 6. Huh?
6, my lord.
And the respondent number 6. Also, in the event, also respondent number 6. In the event there arises any question of any delay in institution of such proceedings, the learned trial court shall consider that the matter shall, while considering such application for condonation of delay, shall reckon that the issue involved, that the issue that would arise before it was so pending before this court in the present writ proceedings. So, with the above observation, dismissed as withdrawn with liberty, huh? I'll write the facts, don't worry. इसको ऊपर का facts दे देंगे.
I'm sorry.
Yes, Mr. Goswami. Give me a way out, because this, I missed it out. Mr. Mozumdar has pointed out that this CD had traveled with the case diary to the trial court, or the court of the CGM at least. Not the trial court, CGM court.
Special judicial magistrate.
No, it did not reach, whoever it is.
It had reached.
Special,
It had
but in
reached,
under
my lord.
the,
Thereafter,
it did not go to the session court. It did not reach the session court,
my
but
lord, what had happened, in fact, my lord, when the accused are summoned, after that, there is a stage called copy. During the stage of copy,
it was found. Statements were not there.
the CD disappeared.
Statements were not there.
Statements were not there.
CD
The case diary, entire case diary disappeared.
CD contains 161 statement.
Entire case diary.
Nowadays, I find, I don't know whether it's here in Arunachal, I find that the 161 statements that are relied upon are typed out and annexed to the copy of the charge sheet.
Charge sheet, yes. Along with the charge sheet, they have to give the copies of the case diary.
Statements. No, the statements of the witnesses,
And 161.
exam 161 statements, 164, all are typed out and put there. I don't know what the procedure is. Because CD otherwise is of no use to the trial.
No.
It cannot even look into it. So the trial, that CD is not a part of the charge sheet.
Yes, it is.
If I'm not wrong,
Yes, yes.
CD cannot be a part of the charge sheet.
161 statement is relied on only for the purpose of contradicting.
Contradiction. So that is not a part of the case diary, of the
Case
charge sheet.
record, yes. But in this case, just one more relevant aspect, they have approached after 35 years of the incident.
No, that more so, if a person he has lost a relative, he would like to see the proceeding to its logical end.
Absolutely, I am only indicating.
And it shows very badly on the criminal administration system that a case like this is lying down for last 35 years. And
I'm only saying that.
we know that
Had
case.
they, we know everything, when records your lordship has seen. Had he approached the Supreme Court after 2-3 years, matter would have been different. After 35 years, because there are
Yes,
reports.
give me a way out.
I have got reports, because pursuant to an order passed by the Supreme Court on 30th of November 2021, if your lordship finds, by Honorable Justice Surana, there were not one reports attempt to reconstruct the
The
case diary.
reconstruction.
They have
would be
said that those people are not there.
there. 36 people are witnesses were not are there.
They currently reasoning.
Now,
Hello, yes.
yes, Mr. Goswami, tell me,
Most shocking.
how,
aspect of
forget
this-
what has
Hold on.
happened. How can we take this matter forward? Have you had a talk with Mr. Bora? Because he's an amicus here.
Yes, he was appointed to amicus, but he hasn't attended any of the proceedings thereafter.
Mr. Majumdar will act amicus, we don't want anybody else.
Well, what had happened? Well, the case herein is such that this is not a very unusual phenomena that case records go missing from trial courts. From my limited personal practice in the trial courts, I have noticed. I have even personal experience.
Where is the case now pending? Has it reached the,
Judicial magistrate?
it has not reached the session court?
No.
Committal proceedings cannot be done because copies have not been,
There is no question of there being a committal proceeding.
because of the copies not being
Yes,
given.
copies not punished. Now, Lordship, I will like to just bring to your Lordship notice some information which I had sought for, and this now appears to be contradictory with the affidavit filed by the.
You do one thing.
Yes,
Mr. Goswami, if there is any such material, you bring it on, because we will have to now at least lay down the manner in which a CD is to, because CDs are to be prepared in duplicate for normal cases, and in special report cases, it has to be triplicate. Now here, academically, we know if the IO or the officer in charge loses one CD, we will get that CD in the SP office. If that goes in a special report case, we'll get it in the, what do you call that, PP? No, that attached to the PI code.
Yes.
We'll get it in the PI code.
Well,
But here it seems that only one CD was prepared.
No, my lord. That was what my learned friend on the other side said that as per procedure, they prepared 3 CDs. But here, there is no trace of any other CDs.
It's not there.
Yes, it's not there. Whether they have prepared now, whether they follow the rules.
There is one document here of an additional PP of the court
Yes.
receiving that document. But unfortunately, that learned counsel is no longer in this world.
That is understood. But whether the court which is taking up the trial gives away all the responsibilities to the additional public prosecutor, even if the case diary goes missing, my lord. Does not the court have any responsibility?
See, normally the presiding officer is not the one, although he is the custodian.
Yes.
Everything is with him. But in fact, he is not the one. He has to rely on his office people.
Hello.
And the whole CGM building, everything was searched, not once but twice. Even an inquiry was made by the vigilance of our
Yes,
department,
Lord.
not found. So what is the way out?
The way out now, so if
Now
this-
blame game can be done. We can go along for another 10 years playing this blame game.
At least,
But we'll have to see how we can go
yes,
forward.
but at least some inquiry by an independent authority as to whether these records now from the report, there is no specific.
Okay,
statement.
you said that you have got some RTI replies.
RTI reply, it is in the writ petition, my lord. I have
Okay.
annexed in the.
And what is the contradiction with that of,
Yes, my lord. First contradiction is that
have you brought that contradiction somewhere on record?
it is on record, my lord.
No, Mr. Goswami, have you, serious matter? You have made certain statements. They have made certain statements, naturally controverting what you have said. Now you say that the statements that they have made is in violation, is not in connivance with the RTI replies.
Yes, my lord.
Show me one.
Lordship may kindly come to page 40 of the writ petition.
Okay.
First query, your lordship comes there, see 4 queries, answers, replies to 4 queries. The IO submitted the charge sheet on 3786 with the CD, but the CD was untraceable at the stage of supplying copy. Hence, the trial courts on various occasions, asked the IO to supply the CD in duplicate and duplicate. Now, my lord. whether
Now
it
you
was
tell
on
me one
various
thing.
occasions-
Okay, fine. Tell me one thing. This matter has been taken up by the trial court before these issues arose, disputes arose. Before you filed this case,
Yeah.
this matter may have been listed before a court, a judge, a special judicial magistrate there at regular intervals.
Yes, sir.
What are the orders being passed at that initial stage?
Well, after, as per, from these documents, it appears that from the stage of copy, since the CD was not there, copies could not be furnished.
So
because
this stage
161
of copy occasion sometime last maybe 10, 20, 30 years back.
Yes, ma'am.
Right? Now, you came up before this court only
In 2019.
19.
Yes.
So, in that period, this matter was being considered by the trial court. Or trial court means the
My lord, since
committal court.
then there had been no, because without supplying the copies, you cannot frame the charge
No,
also.
she
my lord.
says,
Charges cannot be considered.
I know. Hence, the trial court on various occasions and asked the IO to supply the, from where?
Whether it was various occasions.
Where they are saying?
Now, if your lordship kindly takes up the affidavit
Hmm.
with the report filed by the government, my lord.
Hmm.
Respondents. At page 54 of the affidavit, my lord.
Page 54,
Page
okay.
54 of the affidavit.
This is an by principal secretary.
Yes.
Hmm.
May I read it, my lord?
Hmm.
This was only once that this court the trial court in 2011, they had intimated the IO for the case diary, not on various occasions. my lord. Since 1986, the CD went missing in 1986.
This RTI replied that on various occasions the court was asking for.
Court
There are
was-
no order, the order sheet does not reflect that.
Yeah, order
That is
sheet.
what you're trying to
Yes,
say.
my lord.
How do you say that?
My lord, it's-
No, have you seen the order sheets?
I have not seen the orders.
Mr. Mazumdar, have you seen the order sheets?
Which order sheet, of the?
The order sheets of the,
No, madam.
no, because why I'm saying so, if the court had required on various occasions as per the trial court, that the CD be produced, can't the presumption be drawn that the CD was not along with that? If it was also, it was returned and it was with the investigating authorities.
In the?
Investigating authorities.
No, madam. There is nothing like that.
No, if the orders were, say, 3, 4 orders were issued, no response to that from your end, what would be the presumption that can be drawn from by this court? So they will have an order sheet there.
Yes. Better we go through the order sheet.
We'll call for the order sheet.
And so far as the state is concerned, state is no way trying to come in the way of the trial.
My lord, because
No, the state has to now
Yeah.
work out a way. I'm trying to vex my brain from yesterday with my limited knowledge that I have. I've not been able to work out a way how to take this matter forward.
Exactly.
Because if it was 2-3 years old, we could have asked them to re-record the statement. Maybe that charge sheet would have been withdrawn. A fresh investigation could have been ordered. Today, we are not even in a position to issue a fresh
Most
investigation.
of the people are not there.
And Mr. Majumdar, even if we proceed in this matter, it would be having an effect of having an inquiry with regard to what happened to that CD. But the main issue, what will happen to the trial cannot be answered.
Because ultimately assuming that somewhere there are some lapses on the part of somebody, he will be punished. But this, what about the
Trial. That is what I'm more interested. So, Mr. Majumdar, you are the amicus curiae. No, you are the amicus curiae. You be the advocate general additional advocate general in the first half of the hearing, but in the second half, you tell us a way out. And Mr. Goswami, you also work out. Because blame game will take us nowhere.
absolutely, my lord, because my lord, as per the
My
criminal,
lord, there is no
as
point
per the criminal code,
discussing about what has happened. Lordship may
I'll pass.
as per the criminal rules and orders, the courts are required to periodically send reports to the High Court regarding.
Mr. Counsel, are you trying to haul up people for the missing of the case diary, or you want the criminal trial to go ahead? What is your intention in this petition?
Firstly, the criminal trial to go.
Bus, then wait. Heard Mr. D. Goswami, learned counsel for the petition, and also heard Mr. D. Majumdar, learned additional advocate general Assam, assisted by
D. Majumdar, Lordship.
heard by Mr. D. Majumdar, learned counsel representing the state respondents. You are appearing for? High Court. Also heard Mr. E. N. Sharma, learned counsel for N.K. Sharma, learned counsel appearing for the respondent number 4 and 5. Also, Mr. D. Goswami has drawn the attention of this court to an RTI reply given by the Special Judicial Magistrate Assam on 7/1/2015, wherein it was contended that the CD being untraceable, the trial court on various occasions had asked the IO to supply the CD in duplicate and triplicate. Steps were all being taken to issue reminders to concerned IO through concerned SP IGP Assam. Also, the above contention as contained in the reply dated 7/1/2015 would have to be verified from the records of GR case number 121685. Accordingly, the registry shall requisition only the order sheets of said GR case number 1216/85 and scan copies of the order sheets of GR case number 1216/85 from the court of the Special Judicial Magistrate Assam, Guwahati. Also, registry to requisition the same before the next date of listing. Registry to list this matters again on when? After 15th? 19th would be fine. 19th?
I've got some difficulty.
Yes. What do you have?
Let it be 22nd, man.
22nd to 22/8/2024. Also, further submissions of the learned counsel for the parties in the matter shall be considered after perusing the order sheets. Said order sheets also. Mr. Majumdar, please try to find out a way we can go forward. And Mr. Goswami, you also.
Yes.
Blame game can go on daily. There is no end of that. We can give an inquiry. We'll do that. But what would happen to that criminal trial? That's the question. Okay, fine. And let us see if they have been asking, then how the IO was reacting. We'll have to see.
Reacting.
1, 2, 3, 4, 5. You will have the orders next week. I'll list it on a next week and pass. In the meantime, I'll pass the orders. Mr. Burman, I'm sorry, Nipun Burman, I have dictated half. Half is left. I'll do that.
I've handed over the copies of the.
I've got it. Only for that, I waited for that only. Then I found in the file it was not there, but my note, it was written. Okay. Next week, what date did you dispose কৰি দিম এই 14 তাৰিখ আৰু 16 তাৰিখৰ ভিতৰত দি দিয়ক ওপৰগিটা 14 তাৰিখে দি দিয়ক 1 2 3 4 5 টো একেদিনে দি দিব 14 তাৰিখে দি দিব আৰু 6 টো 16 তাৰিখে দিব
Item number 4 is concerned, my lord. If you lost it permit, I would like to draw attention of one paragraph of respondents, my lord. Either next date.
What was the order passed? No. What happened? Show me.
So far, item number 4, my lord.
4. 4 I have not dictated, so I forgot. Let me see. उकील का नाम लिखेंगे नाम फाहमी Yes. We said we'll pass the similar order.
No. This is different, not analogous, my lord.
Okay. What do you want to show?
My lord, though it is for delivery orders, my lord, if lordship permits, I will draw the attention of the lordship, one paragraph of the respondents, my lord. That is paragraph number 22, my lord. But other side is not there, my lord.
Paragraph 22 of your writ petition.
No, respondents affidavit, my lord.
This is item number 5.
4, my lord.
530222.
520517, my lord.
Beleg dila. Hey, to beleg dila. 4 Bonojit Das. No, 4 to 9. Bonojit Das. 5205. Hmm? 4 like. Yes, Mr. Chan. Oh,
That's my trust. Actually,
yes.
last occasion, my lord, is your lordship opined that he has committed misconduct, my lord. Only to just respect, my lord.
Where? Which one you want to point out?
My lord.
Which paragraph you want to point?
18, 21 and 22 of respondents affidavit.
Hmm.
18, my lord. That with regards to the statement made so and so of the petition, the answering dependent humbly begs to state that the petitioner was removed from service by the commandant so and so. Now, Kajalgaon, following the all prescribed procedure on the ground of unsuitability under SSB Act and SSB rules, my lord. Now come to the paragraph 22, my lord. 22, with regards to the statement made so and so of the petitioner, the answering.
Okay, got it. What do you want to submit?
My lord.
What is your submission?
My submission is that he was removed under rules 18 subsection 2, Roman 2. Roman 2 on the ground of unsuitability, my lord.
Okay, you have who is for the respondent?
Respondent,
Mr. RKD Chaudhary was. You inform him. We'll list it on Thursday. On Thursday, we will list it. Yes, Mr. Sharma.
Item number 6.
16th.
Lordship, I have a small trial, Lordship. Lordship, original record of the departmental proceeding may be considered.
We'll do that. We'll do that because we have not been able to sit down for that. We'll do that. On 16, we'll pass the orders. The original records have been handed over. Original records. It's given. No, you have it with you.
Yes.
Huh? You can hand it over to.
Yes.
Hey, ata gayano record dibo. Original records. Ma to order da pas queries. Excellent. Item number kiman asal? 6. Miss Pusap, the matter was listed for delivery of orders today. Pusap, however, Miss A. Gain has produced the original records of the case, which is taken on record, and the date of delivery of orders is deferred to 16/8/2024. Full stop. Huh? 68 order to record to Luilobo.
Record, I'll give the matter tomorrow, my lord. My lord, actually, directly I came from Delhi today for my son admission. So that tomorrow, otherwise not. Today, if courts want today, then I'll.
No need. Tomorrow.
Tomorrow.
Etu? Ekul na lage likhibo. Miss A. Gain submits that day. First, the matter was there fixed for delivery of orders today. However, Ms. A. Gain submits that the original records in the matter shall invariably be produced by her tomorrow.
Yes, tomorrow.
Also, accordingly, registry to list this matter again on 16/8/2024 for delivery of orders. The Ms. Gain shall furnish the records or in original before the court master tomorrow.
My lord, tomorrow, on 16, whether my presence is required or not, madam. But I'll not be available, that's why.
When are you available?
My
Next
lord,
week?
My lord, I'm available on July.
14th, 16th. Then it has to go to 2nd because I'll not be here.
Okay. Then, my lord.
2nd?
Second?
2nd?
Second.
2nd of November, September?
Yes, ma'am.
2/9 ko idea. In the meantime, I'll start my dictations if
Yes.
I find, because I'll have some free time these days.
Yes, ma'am.
So if I start my dictation, if I have some problem only, I'll ask you on that day. Others, I'll deliver the order. Okay.
In between 13 to 21, I'll not be.
No
able
need.
to because of it.
We'll have it. Everybody should be satisfied. Mr. Chan, item number 4 likha. The matter was fixed for delivery of orders today. However, Mr. Chauhan has prayed that he be given a further hearing in the matter. Accordingly, registry to list this matters again on 14/8/2024. Also, Mr. Chauhan shall inform the matter to the learned DYSGI. Shall inform the learned GYGSI appearing for the respondents about the next date of listing. Also, registry to list this matters again as a top of the list matter on 14/8/2024 for further hearing.
Can it be 16, my lord? 16.
14, you have any problem? Personal problem? Huh?
Some others case my dear, my lord.
Case was. You come down 5
There is
minutes.
no problem, my lord.
You come down 5 minutes.
My lord.
Because I get 14, 15, then I can dictate it. That's why. That's right. Otherwise, file will go with me because I'm not here from 19th. So it'll be difficult.